esteemed Minister of Justice, esteemed participants, ladies and gentlemen, I would like to welcome you all to the International Summit on the National Human Rights Institutions and their enhancing role in protection and promotion of human rights, which is organized by TİHEK. We are glad to host you here. Welcome, everyone. Before proceeding with our program, I would like to invite you to a minute of silence on the memory of Gazi Mustafa Kemal Atatürk, father of our republic, and the martyrs, and then we will have our national anthem. First, we will start with the message sent by the President. Esteemed members of TİHEK, esteemed guests, I do extend my deepest regards with all of you. And I do hope that International Summit on the National Human Rights Institutions and their enhancing role in protection and promotion of human rights will be beneficial for first the victims and for everyone. I do congratulate you for your success to organize this meeting. Indeed, we have established our country with the principles of help humanity so your state will last. And in this manner, we are hosting the crowded population of refugees in our country. We are hosting many Syrians and other nationalities who are forced to leave their countries. And also with a perspective to enhance the freedom and rights of our people in every segment, we are still continuing our reform efforts. When we compare our country with the situation 20 years ago, we are in a very advanced position at this point. And in a world where terrorist attacks do increase and where extremist motions have increased, we are putting all our efforts to improve the situation in human rights and freedoms. And we do believe that these kind of meetings and efforts will contribute to our work as well. Once again, I do wish you a very fruitful meeting and extend my best regards Recep Tayyip Erdoğan, President of Republic of Turkey. And in order to deliver the opening remarks, I would like to invite Chairman of Human Rights and Equality Institution of Turkey, Professor Dr. Muharrem Kılıç. The floor is yours, sir. Esteemed Minister, esteemed Deputy Ministers, dear members of protocol, dear members of press, esteemed guests participating from across the world, I would like to welcome you all. As TİHEK and the international arena, we do believe that human rights institutions do not face just local problems, but also there are certain regional and global problems. And in order to identify those problems and the possibilities to solve those and to have cooperation in a better level, we wanted to have this important organization, and with your participation to our meeting, we will be elaborating the possibilities. First of all, for the organization of this international summit, both academically and administratively, there have been support from different countries, ombudsmans, and I want to thank all those international organizations who have assisted us during the process. As I've stated earlier, the aim here is to deepen the relations in between national human rights institutions and to discover potential cooperation areas for the improvement of the situation. We would like to have deepen our institutional relations and cooperations as well. We do have invaluable ombudsmen and representatives of international organizations. And by taking this opportunity from Georgia to Azerbaijan, from Germany to UNDP representatives, from Denmark to Uzbekistan, from Georgia ombudsman to UN commissioner, from Albania to many other institutions. We have representatives here, and we are glad to have them. As you do know, in three essential areas, we do conduct our activities to protect human rights and freedoms. And we are fighting against discrimination and prevention of any ill will. We do have such significant role in the field. As it has been stated on the literature, relevant civil society organizations, national governments, and international organizations do comply with the rules of international conventions on human rights, and it is important to reflect such conventions to the implementation. In the literature, this has been identified as the fourth sphere, and in this fourth dimension, no NGOs, no national governments, neither the institutions' representatives take this role on the fourth sphere, but on the fourth sphere, there are efforts in an independent manner just to protect human rights. Dates back to 1993 for the Paris Principles. Certain duties have been identified for the national human rights institutions. The rules have been identified, and among those rules, we have the establishment of the understanding in regard to human rights and the supervision of these rights implementation. Aside from establishment of such an understanding, there is also one role for the elimination of any infringements in regard to human rights and freedoms. The principles foresee elimination of any infringements. Of course, public authority has a certain role for the protection and for the protection of human rights and freedoms. National human rights institutions do have a complementary role. There is certain gap which could not be performed totally by the national governments. And at this point, we do have current problems that we are facing globally, and we will be discussing all those through our summit. And the first problem that I would like to mention is the climate change crisis. Aside from climate change crisis, there are certain issues that we need to discuss and we need to elaborate to find out possible solutions. We will be creating new perspectives and approaching the issues with a new manner. Climate change is affecting us hugely. Not just us, but the whole world is under the influence of climate change, and it creates certain inequalities. And we do see there are certain infringements of human rights derived from this climate change crisis. Unfortunately, this climate change threatens the livelihood of people and their lives. Let me share a couple of data. In accordance with the UN data, in the last decade, 23.1 million people have been affected because of the climate change, and they have been displaced because of that. And World Health Organization published another data in between 2030 to 2050 because of malnutrition, diarrhea, and heat stress. Every year, there will be deaths of 250,000 people. This has been foreseen by World Health Organization, and surely with the meteorological incidents and events, this humanitarian crisis caused by climate change affects vulnerable groups at the most, and there are certain issues which is waiting for us in the future, and the situation will be deepened even. We do see there are a crisis that we need to face, and for the fourth dimension, the ecosystems rights and the fourth generation rights, the acclamation of those rights are hugely important, and global climate change do threaten these situations tremendously. Right to health, right to accommodation, right to nutrition are under danger because of climate change. And of course, under under these circumstances, vulnerable groups have been affected the most, and their situation is quite critical. And within this perspective, in the first place, we need to just follow the national conventions in order to resolve the situation caused by the climate change. We do have UN Climate Change Convention, we do have Kyoto Protocol and Paris Convention, and Turkey has been a party to all those conventions and protocols in order to have regulations in line with the requirements. And in our 11th development plan, there are policies identified in this manner to eliminate the threats. And in this perspective, we can say that current approach of Republic of Turkey shows the paid importance to this critical issue. This human rights vision is now incorporated with the climate change perspective, and there are concrete goals identified by public policies. With public policies, the threats caused by climate change would be identified, and in line with the identified threats, there will be concrete steps to be taken. And the question of what can international organizations can do about climate change within the perspective of human rights. Surely sustainable development is important, and elimination of climate change crisis could be achieved with the responsibility taken by the human rights organizations as well. And when we check the goals, the establishment of climate goals, elimination of crisis should be understood from the perspective of not just ecological but also humanitarian perspective. We need to underline this issue more. And also for climate change, what kind of political tools or arguments could be raised by international human rights organizations? The research papers and surveillances should be performed. And as a TİHEK, we have started a reporting process, and it is an ongoing process at this point, but by the end of the year, we will have a very comprehensive report to be shared with public. And then again, in human rights reports, in line with our laws, every single year we have to submit human rights reports to the presidency and to the Grand National Assembly of Turkey. And of course, for the best practices, Croatia Ombudsman had reports in regard to the climate change and its impact on human rights dating back to 2015. It is not just possible to have elimination efforts based on just these reports, of course. The application procedures do have an important role in this manner. We need to also evaluate the situation upon the applications of people as well. There are policy recommendations to the national governments and also to the international organizations. ISCOT, which is human rights institution, and there are certain joint efforts among these associations and institutions. As I've stated, we need to have monitoring activities, especially in Africa. International human rights organizations, they have effective activities on the field for the rights of women, for the rights of children. They do identify any infringements. And from Latin America, we do have another example. For example, we may see the direct relation and infringement of rights caused by the climate change crisis. As the institution and as with the stakeholders' activities, I can say that all those efforts are quite valuable to understand the situation, to acknowledge the current problem. And by taking this opportunity, I would like to say something for the representation. We do have valuable international organizations participating here, and I would like to thank them. And we do hope that there will be further collaboration in between our institutions, and we will have deepened relations. Another framework that we will discuss is that the relation between business world and human rights. Business world cannot be separated from the topic because not just public administrations, they have violations of human rights, but also business world should be observed and monitored, because in a private sector there are millions of people putting their efforts and trying to get their bread from the work. And for that, since 2010, globally, there is an emerging area for the identification between the relation between private sector and human rights. For the doctrine, we do see there are lots of researches and studies claiming that business world could be just violating human rights and freedom. So in that regard, this is a topic that we are paying attention hugely. And in 2011, there have been principles that we have adopted, and in national human rights institutions do not follow the norms of national regulations, but also we do have international rules to cooperate and identify the issues at a global level. As a TİHEK, as a human rights and equality institution of Turkey, I would like to state this. Within the scope of a project, we will have a reporting process on business world and human rights. This is one good news from our side, and we do believe that there will be added value with this report, and business world's representatives and the workers, labor force in the private sector will contribute to our findings. It is not just surely the business world, but consultation services are crucial. As TİHEK, we do believe that consultation services will get benefit from the reporting process of business world and human rights effort. Denmark Human Rights Institute have particular studies in this perspective. They do have coordinating and they do have coordinating activities, and they do provide recommendations to the business world as well. With the representatives of business world and labor force, they do conduct meetings, and through their studies, we can see many good practices. And also from Austria, we do see that are similar good practices based on business world and human rights, and I think awareness raising activities will be at the utmost importance for the future. In order to deepen the institutional relations and coordination, what kind of a language, what kind of an approach, communication that we can build to have better results. We will be focusing on the answers of this question throughout our summit. As a human rights and equality institution of Turkey, we need to follow a certain communication strategy. We need to have a visibility on social media, and we need to have a public awareness for our activities in order to reach our goals. As you do know, for the protection and enhancement of human rights, and attitude and action should be transferred to the public, and not just by civil society organizations, but also all authorities. They have this sole duty to inform public. In order to improve the situation, we need to have a constructive approach. We need to have a constructive communication strategy, and within this perspective, not just in a national scale, but also in global scale, this major human rights organizations and activists do follow a significant path, and they do just point out infringements or violations. We do see that they are following the shaming of institution. Name and shame is the terminology which is used by many of those organizations, but it is not a constructive way to do it. As a human rights and equality institution of Turkey, for the media tools, for the communication strategies, we are not adopting that strategy, but we are following a much constructive approach. And In order to raise awareness for human rights, we are creating a much constructive perspective and approach. We do have this principle, hope-based communication, and within that framework, we do see that we need to resolve the situation. We need to have empathy. We need to have a constructive attitude. And certain agencies, they have this 10 principles to have an effective and constructive communication. And in general, what we can say, identifying, pointing out the violations, name and shame could create an antipathy for our efforts. And in order not to have such antipathic approaches and create an empathy for our efforts, we need to adopt the contrary communication. And for the accreditation process, this will be my last talking point. In order to have a certain capacity at the national human rights institutions, we believe that accreditation is a very important process for the public reliability and for the competency of the institutions. Accreditation is crucial. And Ganri subcommittee of accreditation have a framework, and this framework follows the superior normative forms. We need to have this holistic structural norms to adopt in our institution. Of course, through accreditation, there is also the effective and efficient implementation of the rules and principles. Last year, it was announced by our esteemed president, and we do see that this is a goal to adopt to have the accreditation. And in our national action plan, there is a goal to increase the capacity of human rights institutions in our country. And in line with this goal, Human Rights and Equality Institution of Turkey's accreditation to GANRE is another goal. And as of this year, globally, there are 118 national human rights institutions integrated to GANRE's system, and they do have accreditation. In the accreditation process, independency of the institution, pluralism, and accountability are core principles. Those are highlighted principles. But I would like to state one more thing. It is not just Paris principles competencies, but also there are certain issues that we need to have. The relevant requirements set should be adopted by the national human rights institutions. Freedom to seek for rights and not having an effective performance, for example, do show weak signs of competency for those institutions, and it is not possible to have an efficient and effective process through incompetent institutions. Of course, pluralism, independency, accountability will be our core principles, but we need to have a broader perspective to interpret all those requirements, the performances which have been shown by the institutions. Should be cleared for our institution. We are performing at a very desired level for all those three areas, actually. And by taking the opportunity, once again, I would like to thank to the participants of this international summit. I hope that this will be beneficial for everyone, and in this process, for the administrative issues and for the institutional level, there have been cooperation efforts by my colleagues and by our participants. I would like to thank every one of my colleagues, to the representatives of international organizations and public institutions. Thank you so much.
I would like to thank the head of TİHEK for their speech, and I would like to invite the Turkey's resident coordinator of the UN, Louisa Vinton. Sayın Başkan, Sayın Adalet Bakanı.
Ladies and gentlemen, dear colleagues and friends, good night and good morning. On behalf of the United Nations Development Program in Turkey, it's both a pleasure and an honor for me to address this important international summit organized by our esteemed partner, the Human Rights and Equality Institution of Turkey. And let me start by commending TİHEK for convening this event at a time when human rights challenges we see emerging around the globe are particularly widespread and pernicious, and when we are confronting what our United Nations Secretary General Antonio Guterres has called new frontiers in human rights, in particular, as our chairman has underlined, the dire implications of climate change for the rights of future generations. The agenda for this summit is thus both topical and very timely. As you are all aware, human rights is one of the three pillars upon which the United Nations was originally founded as a multilateral institution, and we at UNDP and across all the United Nations family more broadly are proud of the role played by the Geneva institutions as a cornerstone of human rights globally. In light of the challenging global context, our UN Secretary General has sought during his mandate to revive and reinvigorate global action on human rights. In 2020, he sounded an urgent alarm bell, warning that the cause of human rights faces major challenges and no country is immune. Disregard for human rights is widespread, and we see egregious and systematic human rights violations, rampant impunity, rising hate speech, misogyny, exclusion and discrimination, social polarization and loss of civility, environmental degradation, and unequal access to resources and opportunity. To respond to these global threats, our Secretary General issued a call to action which identified 7 focus areas for a special activity. And those are the urgent achievement of sustainable development, the protection of all people regardless of their circumstances, tackling gender inequality once and for all, ensuring robust civic space for everybody, creating a healthy environment for future generations, and here again we return to climate change, as I think we will again and again, ensuring a safe digital world, and finally, all pitching in together to make this a reality. So the spirit of international cooperation and learning from each other that we see reflected in the agenda for this international summit. This is quite a daunting agenda, given the global challenges on human rights, and it's one in which national human rights institutions like TİHEK have a crucial and central role to play. It is national human rights institutions that serve as a bridge conveying international human rights norms to the national level, and it is not unusual for national human rights institutions to find themselves a lonely voice standing up for the often embattled principles of equality and non-discrimination. National human rights institutions are also assigned a key function in the quest to achieve Agenda 2030, the famous Sustainable Development Goals. Under the crucial Sustainable Development Goal number 16, the governance goal for just, peaceful, and inclusive societies, the establishment of fully independent and effective national human rights institutions is treated as an indicator of success in creating the institutions for responsive, inclusive, accountable, and transparent governance more widely. UNDP sees itself as a natural partner to TİHEK and other national human rights institutions in neighboring countries across the wider region and around the world. And I am pleased to see colleagues from national human rights institutions in other countries where I've worked previously, specifically Croatia and Georgia, as speakers on the agenda for this summit. Much of UNDP's programmatic work on human rights is dedicated to helping national human rights institutions strengthen their capacity to discharge their often daunting responsibilities and to achieve the lofty standards set in the UN Paris Principles. Globally, UNDP has been working since 2011 in a tripartite partnership with the Global Alliance of National Human Rights Institutions, GANRI, and the Office of the High Commissioner for Human Rights to support national human rights institutions around the world. This partnership sees great value in sharing experience and peer-to-peer coaching and mentoring among different national human rights institutions. And we see, as I said earlier, this summit as a good example of that experience-sharing approach. In Turkey, our support to TİHEK has included a capacity assessment concluded in 2019 that compared the institution's current role, reach, and resources with what would be needed to excel in fulfilling its mandate in line with the Paris Principles. The findings of that capacity assessment remain relevant today and include buttressing institutional independence, expanding staff capacity to conduct proactive assessments of discrimination on behalf of vulnerable groups that often lack the voice to be heard on their own, and building internal skills to conduct inspections in all types of places where people are deprived of liberty as part of a zero-tolerance approach to torture. Wherever relevant, UNDP remains keen to support TİHEK in implementing the many recommendations of this assessment. We're also delighted to see the high level of aspiration reflected in TİHEK's decision in July 2021, which the chairman has mentioned already today, to seek accreditation by the Global Alliance of National Human Rights Institutions. GANRI accreditation is key to attaining recognition for compliance with the international gold standard for national human rights institutions, namely the Paris Principles of Independence, Pluralism, and Accountability. And here I would say we see quite a diversity in the structure and organization of different national human rights institutions depending on local specifics, but we do see a very relevant stress on the three areas of independence, pluralism, in encompassing the widest views of all society, and accountability and the broadest possible ambition in dealing with human rights challenges, taking a proactive approach to, rather than a strictly reactive approach to the threats and challenges we see to human rights every day. We'll be watching closely when TİHEK's application is considered this October, and we commend again this initiative. Ladies and gentlemen, for me, as a 20-year veteran of the United Nations system, one of the beauties of the Geneva institutions and the UN-led human rights system globally is its ability to adapt and evolve as conditions change, and as human thinking itself evolves on the nature of equality and the nature of rights. We have seen how the crystalline principle of Article 1 of the Universal Declaration of Human Rights, all human beings are created free and equal in dignity and rights, has become more inclusive over time, building legal and practical foundations first for equality between men and women, then for the rights of persons with disabilities, and more recently for prohibiting discrimination on the basis of sexual orientation and gender identity. This is not always a smooth process, and it tends to move in fits and starts, with practical implementation always more challenging than setting standards. But even where implementation is a challenge, we see the setting of standards and the clear articulation of principles as valuable in its own right. This process continues with a focus on human rights now in these new frontiers that our Secretary General referred to and that our chairman has also articulated so well today, namely human rights in business and climate change and human rights. 2 days ago, here in Ankara, UNDP launched a new project focused on business and human rights, in which Turkey is one of 17 countries where we will be working with private sector companies and government authorities on how to identify, prevent, and mitigate adverse human rights impacts of business. And here we're putting a particular focus on global supply chains because we see one of the negatives of globalization is the tendency of some actors in the business sector to outsource their less savory practices to areas where enforcement is less active and less effective in areas such as child labor, the right to organize, and the right to earn a decent wage. We're very happy to see this topic feature so highly on the agenda today, and we look forward to a contribution from my colleague from our UNDP regional hub in Istanbul on this topic. As to climate, we are seeing increasingly how the issue is shifting from one of the threats that climate change poses to human rights, to the idea of a healthy climate as a human right in and of itself. And we were very pleased to see in the recent Stockholm Plus 50 conference, recognizing 50 years since the first major environmental conference in 1972, recognizing the right to a clean, healthy, and sustainable environment for everyone. And we see this as a very constructive way to proceed in trying to engage all actors, governments, businesses, academics, civil society, in really effective, ambitious action to fight climate change. And my colleague Nuri will be speaking on that topic today on a panel devoted to climate change and human rights. Looking ahead, we see it as crucial that TİHEK has the resources it needs, not just the legislative role, but the resources in terms of human capital, in terms of funding, in terms of authority that it needs to rise to these new challenges and the new frontiers that we're sure we will see emerging on human rights in coming years and decades. Please know that you can count on UNDP's support in this effort, not only to TİHEK and other national human rights institutions, but more broadly to the cause of human rights, equality, and non-discrimination that we see reflected so well in the philosophy behind the Sustainable Development Goals, where we say to leave no one behind as our core value now and going forward. So thank you very much for your kind invitation to speak at today's International Summit. And as UNDP, we look forward to very constructive discussion and to future collaboration in the important area of human rights. Thank you very much. Teşekkürler.
Sayın Muhkim temsilcimize konuşması için teşekkür ediyoruz. Şimdi de Avrupa İnsan
I would like to thank the resident coordinator for their speech, and we will share the video message of Saadet Yüksel. Ministry of Justice, esteemed participants, I would like to salute you all from Strasbourg. Because of my duty, I cannot attend the meeting physically, but in enhancing the human rights, national human rights institutions are playing a great role. And since we understood that development of the human rights law cannot be only considered an internal legal issue, and there have been many changes in transnational legal regulations and international human rights conventions, and the National Convention on Human Rights has been an important point in 1950, and with the convention, European countries were obligated to and the ECHR dictates that the convention was not only prescribing obligations for the national institutions, and it was a transnational, international legal obligation. And in the member states, a population above 650 million people, and ACHR is playing an important role in ensuring the human rights in this great area. And this is an important indicator of ensuring human rights institutions, and the ECHR has developed a legal base over the years, and with the experience that they have developed, then they are operating as a judicial mechanism in this area. And the human rights field has been developed more and more since the 50s. And modern states are the main actors of for the development and enhancement of the human rights, and modern states continue to be so. And the Convention on Human Rights and the European Court of Human Rights also accept that the national institutions play a primary role, and the states strive to solve the problems in their internal legal systems. And if they cannot solve the problems, then they move to the ECHR and the national courts. Also in Turkey, example, are responsible for, and they are the first responsible institutions for the human rights. And since the day individual application right was introduced to the Turkish legal system, our institutions have played an important role in ensuring human rights in internal legal system. And around the world, legal systems for the protection of human rights are being enhanced. And this important role that TİHEK played in Turkey, it must be considered in this framework. And this semi-judicial institutions are playing an important role in elimination of human rights violations, and this can only be achieved with the presence of a national human rights institution. Until a case reaches the ECHR, it goes through a long process in the internal legal system, and our judicial institutions are playing an important role. And I am proud to be a part of this conference and this cooperation. I would like to thank TİHEK for their kind invitation, and I would like to wish you all a productive conference. And I would like to invite our Minister of Justice, Bekir Bozdağ, to the floor for their speech.
Türkiye İnsan Hakları ve Eşitlik Kurulu'nun çok saygın başkanı,
Esteemed head of TİHEK, UN resident representative, and esteemed participants from all countries, and distinguished participants from our country, I would like to salute you all with heartfelt feelings and the greetings of the God. Today we are going to discuss the past and the future of the human rights institutions, and we are also going to discuss the enhanced role of the national human rights institutions. And we are here for the opening of this summit. I hope that the summit will be successful as planned. and both
saygınlık
national
ilkelerini
and
ortaya
international
koyacağını
esteemed
görüş, öngörü
participants
ve
will be
bu iletişimlerin
contributing with
hep
their
Atatürk
valuable
için, özellikle
comments
Türkiye'miz
and
için son derece
criticism,
yararlı
and I
olacağına
believe that
en
their
önemli noktalardan
contributions
ifade
will
etmek
be
istiyorum.
very
Türkiye
beneficial for
hukuku
Turkey.
üstünlüğü,
Turkey is a
hukuk devletinin
country where the
güçlendirilmesi,
rule of law
demokrasimizin
and
güçlendirilmesi ve insan hakları
the
alanında
enhancement
son
of
derece
democracy and
önemli
human
reformlara son
rights.
20 yıl içerisinde
And during the
imza atmış
past
bir ülke.
years, during the
Türkiye'de
past 20
bugün
years,
Türkiye'nin düzeninde
we
insan
have
hakları ve eşitlik
made
kurulunun
great
ilk
progress,
kuruluşu 2012
and
o zaman
establishment of
ismi
TİHEK,
Türkiye
who
İnsan Hakları
organized
Kurulu,
this
daha
summit
sonra
today,
kurulu Türkiye İnsan Hakları
was in
ve Eşitlik Kurumu olarak
2002,
değiştirerek bu kurumun hem insan hakları hem
and the
de
first
eşitlik
name
konusunda
was
Türkiye'mizde
the
ve uluslararası alanda etkin bir
Turkish
rol
Human Rights
oynaması için
Institution, and we have changed the
saf
name
ve
to the
bağımsız ve çoğulcu bir
Human
yapı
Rights and Equality
kurulmasına
Institution of
yetkilerini,
Turkey,
sorumluluklarını
to make it
çok
a
net bir şekilde
pluralist,
tanımlamasında fayda
effective
olduğunu mülahaza ederek
institution,
esas bir
and to be
altyapı olarak
recognized by
Türkiye'de
the
insan
law.
hakları
That's how we
sorumluluğuna
established the
tanımlanmalı.
legal
Bugün burada sayacak
basis
çok
of
vaktimiz
these
var.
institutions.
Ama
Of
insan
course, I don't
hakları
want to take too
kurumları
much time
ve
by
tebliğ kurumları bir
counting all
kavram.
the human
Esasında
rights
insan hakları
institutions,
kurumları
but it
insanların
is of
bir
great
odada
importance
aramak
to
için müracaat ettikleri
discuss the
kurumlar.
national human rights
Bilgi,
institutions.
ayrım,
People
hakkı
go
olmayan
there to
onların varlığı da
use their
Türkiye'de
right to
yaşanılan
legal remedy,
değişikliği
and the
bir anlamda
presence of a
gerçekleştirir. Bu kurumlar
human rights and
karşısında da
equality
aynı şekilde
institution in
denetlenmesi anlamına
Turkey
gösterir.
means
Türkiye
that
İnsan Hakları ve Eşitlik
the
Kurumu bu
violations
anlamda
are
tarihindeki
now
ilk
audited
sahnedir.
in Turkey,
Türkiye
and
kadın
TİHEK
hakları
plays
konusunda
a
ve diğer
historical
haklar
role.
konusunda önemli adımlar
Turkey
atarken
has
bunlar
made
aynı
great progress
süreçte
in
daha
terms of
farklı
women
ve
rights,
birçok
and we
adım
are
atarak
also monitoring
örneğin
closely the
anayasamızda kadın
developments in the
haklarıyla
world.
ilgili pozitif
And
ayrımcılığı
we have
bir temelin
included
olarak koydu
positive
ve bu
discrimination
pozitif
in
ayrımcılık
our
nedeniyle yasalarımızda
constitution.
yapılacak
And thanks to this
değişikliklerin eşitlik
change,
ilkesine aykırı olarak
now we check
değerlendirilmediği
every
anayasal
amendment in
ve
our
bunun
law
hemen bir göstergesi
for
olarak da
compliance
Türkiye
with
Büyük
this
Millet
approach.
Meclisimizde
And in our
kadın
Grand
ve
National
erkek insan
Assembly,
eşitliği komisyonu
we
bugün Türkiye
established
Büyük
a
Millet
commission
Meclisi'nde
for
kadın erkek fırsat
the
eşitliği komisyonu
equal
kadın hakları
opportunity for men
konusunda
and
her zaman
women,
velilerin
and
katkısıyla
with the
çok önemli
contribution of
değişiklikleri
the
ve önemli çalışmaları
parliament, they
yapmakta
are
ve önemli
working on
faaliyetleri ortaya
very
koymaktadır. Tabii
important
anayasamızın 90. maddesinin sonuna
areas, and they
Türkiye belki de
bring
pek
great
çok ülkede olduğundan
contributions. And in our
bir reformu
constitution,
getirdi.
we have made a
Türkiye'nin
great
taraf olduğu
reform that
Uluslararası
is
İnsan
not
Hakları
available in many
İşbirliği Sözleşmesi'nde
countries.
iç
With
hukukun çatışması
the
halinde
human rights
uluslararası
conventions
yönetim
Turkey is a
hükümlerine
party
üstünlük tanıyan
to,
bir hüküm Türk Anayasası'nın bugün
we
90.
have
maddesindeki hükmü
included
biz
a text to the
kendimize ve ülkemize
Article
uygulamalarını
90
görüyor.
of our constitution,
Hayatımızda
which
çatışma halinde insan hakları ile ilgili bir konu
attaches
varsa
importance to the rule
uluslararası
of law
hukukun
and
üstünlük
human
tanımasını
rights.
anayasal
And if
yükümlülük
there's
olarak ortaya
any
koyduklarından ifade
incompliance,
etmiştir. Biz taraf
we
olduğumuz
solved
uluslararası
that
sözleşmeleri
with the
Türkiye
amendment to
hükümlerinin
our
iç hukukunu da birer
constitution,
parçası haline
and we have
getirdiğimizi
made
baştan
these
ifade etmiştir.
international principles
Tabii
as a part of our
Türkiye bu alanda
internal
başka kurumlar
legal
da
system. Of course, we have
işte
established other
bilgi edinme
institutions in
hakkı konusunda
Turkey
her Türk
for
vatandaşına
the right to
önemli bir
information.
imkan sağladık.
We
Tekrar
have given an opportunity to every
burada dile
Turkish
getiriyoruz.
citizen.
Bilgi edinme
Before,
hakkı
there was a
sadece
right
kendisiyle
to
ilgili değil,
apply
halkla
for
ilgili konularda
a
da bilgi
petition, but
edinme
in Turkey,
hakkını
not only for
anayasal
their
düzeyde
own, but
belirledik
also
ve kanuna
for the
sunmak suretiyle bilgi edinme ve
access to
değerlendirme
public
kurulunu
information.
eğer herhangi
We
bir
have
Türk
established a board
vatandaşı
of,
bilgi edinme hakkıyla ilgili
right to access information, and every Turkish citizen can apply to the Board of Right to Information, and they can use their rights without any limitation. And this board is playing an important role in Turkey. Every action taken by the administration is subject to the judicial review, but the public and the press are also using their right to review administration's actions, but every citizen now has the right to review and criticize an action by the administration, and every citizen has the right to apply for an ombudsman in Turkey. An ombudsman institution was not present in Turkey, and we have included this in our constitution, and we also created a legal basis, and every citizen with who wants to apply can apply at the ombudsman, and with the suggestion from the ombudsman, they advise the administration to review their administrative actions in line with the human rights and the rule of law. And the most important is the introduction of individual application to the Constitutional Court in Turkey. Introduction of individual application to the Constitution Court has evolved our system to make the Constitution Court as a human rights court, and they review the cases to decide whether there is a violation of human rights. In Turkey, we have diversified the ways of legal remedies and provided a basis for the protection of civil rights. And I would like to once more emphasize this diversification. And in terms of strengthening the state's legal side, before we had administrative courts and military courts, and there was a difference between the civil people and military personnel. So we wanted to eliminate this duality, and we terminated this application. We removed the duality in the judicial processes, both in verdicts and the review of cases. We don't have this duality anymore. This was a great step in the judicial area. Turkey was criticized for this duality before, but now I would like to once more emphasize that this duality is not present anymore. Our president shared with the public the strategy document on judicial reforms. And we have taken great steps to introduce this document into our system. And we have also introduced the Human Rights National Action Plan, and we have identified the responsibility areas of each institution, and we have also created a schedule showing the deadlines for realization of our targets, and we have identified more than 300 activities. We have so far nearly 58% of these activities, and we are working towards realization of the rest And some of them are legal amendments, and they are taking more time to accomplish. But I would like to once more emphasize that we are working towards finalization of other activities. The steps Turkey has taken in the area of human rights should be evaluated correctly, and they must be appreciated. This is what we expect from our international stakeholders. And with the reforms that we have introduced since 2002, we have made great changes in this country, and we are decisive in achieving more while taking steps to make human rights more powerful in our country. Turkey continues to make progress in other fields as well. In the international arena, there is a special effort towards creating a negative image of Turkey. Some international organizations and these representatives of European and UN bodies are also involved in this. Once more, I would like to emphasize that Turkey wants to achieve one thing, whatever the subject is. Please be impartial, objective, and fair. We are not looking for any privileged situation. We are not looking to have any privileges, but it is our right to ask for an objective criticism. I would like to give you a few examples. Since the 1960s, Turkey has been working towards becoming a member of the European Union. How many years has it been? More than 80 years. Is that right? 60 years. It's been 60 years. Think about it. We received an appointment for the European Union, and we have been waiting since then. Those who had an appointment in 80s, 70s, in 2000s, they have achieved membership. All of them walked through that door. And now the European Union says if you want to be a member, you have to apply the Copenhagen criteria, Maastricht criteria, and the authorities have confirmed that we meet all the requirements. And there are many countries who do not meet the requirements of Copenhagen, Maastricht, have already received membership. And what do you think about this? The membership process of the European Union, is it working in an impartial, objective way? And is there discrimination against Turkey? Is there an unfair approach towards Turkey? Please put yourself in our shoes. And there are countries who do not meet the criteria and which are far behind us, and now they have full access. And in Cyprus, there was a survey, public survey, and the northern part and the southern part voted. Although they did not meet the requirement, the southern part of Cyprus is now a member of the European Union. Please put yourself in our shoes. Please look at this problem from our society's viewpoint. They said that there are criteria. We met the criteria, and they said there are
Bize diyorsunuz ki
6
şartlar
more.
şu, biz de tamam diyoruz. Şartların hepsini yerine getirdikten sonra
After
6 şart daha var.
meeting all the
Belki
requirements, they
6
said
sıkacaksa
there are
eminim
6
6 şart daha
more
önümüze koyacaklar gibidir.
rights. And I believe that there
Biz
will be
Türkiye
6
olarak
more.
bize adil davranın,
And as
haksızlık yapmayın,
Turkey,
bolşevik
what
olun
we
deme
ask
hakkına sahip değil miyiz? Sahibiz ve bunu
is
sonuna kadar da söylemeye devam edeceğiz. En son Avrupa İnsan Hakları
that
Mahkemesi'nin
please
Türkiye
become
ilkeleri
objective,
ve verdiği
impartial,
kararlar üzerinde
and
de bundan çok
the
fayda görüyor.
decisions
Hatırlayalım
of the
kardeşlerimiz, Avrupa
ECHR.
İnsan
Saadet
Hakları
Hanım also
Mahkemesi var.
mentioned that
Türkiye'de
the
sahip çıkmak.
ECHR is a
Öyle
human
olması
rights
lazım.
court,
Biz öyle
and
söylüyor,
they
öyle de
must
gerçekleşiyor.
behave that way.
Bakın,
This is also
Yunanistan'da
how we
yaşayan
see it.
soydaşlarımız var, Türkler var.
There are
Orada
our
gençlik
cognates living
dernekleri
in
kuruyorlar, spor
Greece.
dernekleri
They
kuruyorlar.
established
Bu
sports
derneklerin
federations, youth
isminde de Türk
federations,
kelimesi
and
geçiyor. Ve
they have the
Yunanlı
word
Türk üyeleri
Turk
bu
in the name
dernekleri
of these
kapatıyorlar.
federations, but they are
Kapatana kadar da
closed by the
Yunanistan
Greek
taşınıyorlar. Yunan
authorities. So the
yargısı
case was brought to the
dernekleri
attention of the
hapsediyor,
Greek
Yunan hükümetini
courts,
hapsediyor,
but the Greek
davaları
courts
bekletiyor,
decided that the Greek
neticesini bekliyorlar.
government was
Sonra Avrupa İnsan Hakları
right
Mahkemesi'ne
about that.
başvuruyor.
And the
Avrupa İnsan Hakları
verdict
Mahkemesi
was
diyor ki
confirmed.
burada
And
hak
then the
ihlali var,
case was brought to the
Yunan
attention of the
hükümeti haksızlık yapıyor.
ECHR.
Yıl
ECHR
2008.
decided that the Greek
Şimdi kaç?
government
2000.
was wrong. And
14
this
yıl
was
sonra
in 2008.
Avrupa
And
Konseyi
today we are in
Bakanlar Komitesi
2022. It's been
toplanıp
14
da
years.
nasılsa
The
bu hak ihlali
Ministers'
kararını
Committee
yerine
of the
getirelim, bu noktada bir
European
karar alır ya da ahim kararını Türkiye'ye
Council
sorup nihayetinde
has
bir karar
not
güne kadar
yet
vermedi. Sürekli
gathered
bir takım
to
şeylerle atıyor.
conclude
Bakın
this
Türkiye'nin
decision of the
uyguladığı ve
ECHR
uyguladığında açık
to
ifade ettiği
push
kararla
Greece
ilgili
to
hemen
accept
anında
the
toplanıyor.
decision.
Avrupa Konseyi Bakanlar Komitesi karar alıyor.
And if
Onların uygulamadığı
this
kararlar
was in
var.
another
Bizim
on
uyguladığımız
another
kararlar.
subject, they
Aynısı
would
Almanya'da
come
var.
together,
Aynısı
the
Fransa'da var.
ministries would come
Aynısı
together
İngiltere'de
in the
var.
commission,
İyi
and
kararlar
they
var
would force
uygulamayan.
us to apply.
Türkiye'nin
But
uyguladığı karar hakkında
in
Avrupa Konseyi Bakanlar Komitesi Türkiye aleyhine bir görüş ortaya koyuyor.
the
Ama
Ministries'
Türkiye'nin
Council of
uygulamadığı
the European
kararları
Council
üzerinde görüşme sırasını beklemeye devam ediyor.
immediately puts forward a
Şimdi ne
comment
yapıyor?
on Turkey's
Duygusal
actions, but for the
okumaya
other countries,
çalışıyoruz.
they don't do the
Ne
same
olursa
thing.
metinde
I know how to
görüyoruz.
read, I know
Burada
how to
Avrupa
write,
Konseyi Bakanlar
I know what is
Komitesi
going on
Türkiye'ye
in
karşı
there.
tarafsız, adil,
I know that
dürüst değil deme hakkım yok mu?
the
Ben bunu dediğimde niye
Ministries
alınmaz?
Council of
Anayasanın bu
Ministries
ameneyi
Commission of the
başkasına
European
dayanır.
Council
Hak
is
etmediğim
not
halde Türkiye'de
fair.
böylesine
They
bir
are
uygulama
not
yapıyor. Hak edenlere yapıyor.
impartial or objective towards Turkey. And I will loudly repeat that in every platform. There are many reports on Turkey. The reporters come to Turkey to meet with the authorities, institutions. But the reason why they visit Turkey to meet with the institutions is to make their reports legitimate. They put in their reports that we met with the necessary institutions and we received their comments. But when we look at the final reports, we see false claims regarding Turkey, and they make the false claims by the terrorist organizations cannot be included in these reports, and we will not consider them as legitimate reports. I shared the official numbers with them, but the reporters don't want to take them into consideration. What they take into consideration is what is shared on press, on media, that is not even confirmed by the official sources. We are ready to do whatever we must do in helping them create these reports. But if they create such reports and if they expect us to meet the requirements of such reports, no, we will not pay respect to them.
In the Turkish Criminal Code, we had lots of amendments. We have lifted the time scheduling limitations for the torture and ill treatment actions. So we are above the international standards, and now they are asking certain questions. What about the torture and treatment? And they do claim that are ill treatments in the penitentiaries. We are asking which ones, and they do not have a concrete answer for that. I mean, if we are asking, we are inquiring the details in order to identify the situation so we can have investigations, and we are ready to take action because we are on duty to perform such investigations, inquiries. They do not give an address. They do not give us a name about this procedures, but they just claim, yes, there are. So how can we investigate that? If this is a rightful claim, then you need to name those people. You need to give us the details in order us to prosecute it, to investigate it. And administratively, we have certain procedures to follow that. No, there are no such details, no naming, and we are just asking against whom, by whom, where, and when. We do not have any doubt to commit our duties. We have public trials. Everyone can follow that. One second, I would like to state this. In Turkish penitentiaries, whomever tries to commit such an action, there will be us standing against them, standing against torture and ill treatment. We do not have any tolerance against such actions. We have zero tolerance policy for torture and ill treatment. So whomever has a claim in this area, please do inform us. And also in press, whenever there is such a news, we do assign our investigators, inspectors to elaborate the issue. And if there are any legal processes required, we do not hesitate. Our conscience is comfortable and we are not apologetic to anyone. Independent from the crimes committed by the individuals, as Republic of Turkey, we have the duty to honor human rights and freedom. It is our duty to protect and preserve those rights. If there are any misdeeds, then we need to be informed, we need to follow, we need to inquire the situation and correct it. But without notifying anything, without identifying any addresses, you can't claim such things. You need to just show us. You need to give us the name. You need to give us the location. Then see the situation if we are protecting the torturer or if we are prosecuting them. There are nobody in Republic of Turkey protecting torturers. Turkish legislation is quite clear on this matter, and we are determined to do the required things. But against all those plots, against all those scenarios, we will be raising our voice and say those are just illegitimate claims. And in our ministry's website, we publish the inquiry and investigation results based on those news and claims. We will continue our transparency and clarity on this matter. In Turkey, in order to strengthen human rights and human rights institutions, We are doing all that we can do. We have done so far, and we will in the future. We will give limitless support to the institutions for the protection and strengthening of human rights. We are dutiful to protect the rights of our people. Of course, it is judiciary to decide over those cases, but as the executive body of this administration, we have certain duties and we will proceed in this way. We are determined, as I've stated many times. And at the end of my speech, I would like to once again wish that this meeting would be fruitful for everyone. And I do believe that there will be results which will make every participant happy. And once again, I would like to welcome our international guest and national guests. I would like to extend my deepest regards to all of you. May Allah be with you. Thank you so much, esteemed Minister. We would like to have him at the stage for a while. Now we will have a family photo. I would like to invite the members of our protocol and all the guests who would like to take part in this family photo.
Değerli katılımcılar, şimdi kısa bir kahve arası veriyoruz. Kahve arasının ardından zirvenin ilk oturumları saat 11.25'te başlayacaktır. Oturumlara ilişkin bilgiler sizlere dağıtılan kitapçıklarda ve salon girişinde bulunan program panolarında yer almaktadır. Programımızın aksamaması adına sürelere uyulmasını rica ediyoruz. Kıymetli Hazirun,
Esteemed participants, prior to the first session, we would like to share the messages delivered to our institution. International Summit on the National Human Rights Institutions and their enhancing role in protection and promotion of human rights. Program is quite important, and you have delivered your invitation, but unfortunately we couldn't be able to participate because of our heavy schedule. We would like to congratulate you for your efforts to strengthen the human rights, and we do wish you all the success in your summit. By taking the opportunity, I would like to extend our deepest regards to the participants. Chair of Turkish Grand National Assembly, Professor Dr. Mustafa Şentop. Thank you so much for the invitation to the International Summit. I regretfully state that I can't be able to participate because of my heavy schedule. Fuat Okay, Vice President. For the strengthening of human rights and for equal treatment, we do know that TİHEK is working effortlessly, and in that regard, we would like to wish you all the success in your international summit on the national human rights institutions and their enhancing role in protection and promotion of human rights. Because of my pre-scheduled meetings, I will not be able to participate. Mehmet Akarca, Chair of Court of Cassation. For the International Summit on the National Human Rights Institutions and their enhancing role in protection and promotion of human rights, you have delivered your kind invitation. However, I will not be able to participate in the meeting because of my schedule. Derya Yanık, Minister of Family and Social Services. I do wish you all the success in your international summit, and I do extend my best regards. Mehmet Nuri Ersoy, Minister of Culture and Tourism. Thank you so much for your kind invitation. Because of my busy schedule, I will not be able to participate to the international summit. For the International Summit on the National Human Rights Institutions and their enhancing role in protection and promotion of human rights, we do wish you all the success in the summit, and we would like to welcome every participant. Minister of Industry. I would like to thank you for the invitation to the International Summit on the National Human Rights Institutions and their enhancing role in protection and promotion of human rights. I would like to thank you for your kind invitation and extend my best regards. Metin Yener, Chair of Human Rights Commission. I would like to thank you for your invitation to the International Summit. It is such a pleasure to have your invitation. I do wish you all the success on your summit. Sheriff Malkoch, Chief Public Inspector. I have delivered your invitation on International Summit, and I do wish you all the success in your summit. Vasif Şahin, Governor of Ankara. Esteemed participants, now we will proceed with our first session with the title of the role of NHRIS in building human rights-based approach to climate change. In order to moderate the session, I would like to invite Professor Dr. Süheyla Suzan Gökalp from Ankara Hacı Bayram University, and I would like to invite our speakers Nuri Özbağdatlı, Maya Hasan Basic, and Nina Eşke. And Ms. Eşke will be participating to our summit online.
Başlayabiliyor muyuz? Başlayabilirim. Değerli katılımcılar,
Esteemed participants, I'd like to welcome you all to our session. First of all, I'd like to thank to the ones who have organized this meeting, who have contributed to the organization deeply. And I do believe that it is quite important to have a separate session, individual session for climate change in a human rights summit. I would like to thank you for this. And the head of TİHEK has delivered a great speech, actually, and he has touched upon the important issues in regard to climate change and human rights. But I would like to mention a couple of things. We have certain ideas in regard to the possibilities, because greenhouse gases and global warming, climate change have impact on all of us, and it will have devastating effects. Obviously, this is not just for future, but also today we do experience it. The pandemics, many other viruses would be on our agenda. This is what we do foresee. And IPCC states that there is a certain global warming and sea temperatures do increase continuously. Melting of icebergs do continue, and sea levels are rising. And also, then again, there is a panel report stating that this change occurring today and will continue in the future will cause negative impacts on the climate, on the habitats, and on the geographies that we do live. In our country, we feel these devastating impacts, the wildfires and floods, and also for the food safety, there are certain concerns. Of course, these harmful effects creates direct threats on human lives. Access to fresh water may lead certain problems. Also, food safety would be a direct threat on human rights. This is not just an envisage for next generations, but this is something that we need to take action, and we do see the impacts already. We do see food shortages, and also in regard to water, we have certain crises. We will need to talk about climate justice. Justice is always a hot topic, and it is something that we cannot reach fully as the whole world. While talking about this, now we are talking on climate justice. Climate justice means that the ones who will feel the impact first and the most needs action, and this term is used in order to highlight an unjust situation, with the acknowledgement of everyone's access to the rights in an equal manner does not fully exercised. And within this framework, countries have different responsibility levels for the contribution to the climate change. Every country has their own responsibility, and against the impacts of climate change, countries have different levels of decisiveness. And for the mitigation measures and for taking responsibility on the implementation of those measures, the cost is a debate, and the conventions state different levels of responsibility in line with their development status. So, within this context, climate change is evaluated as a human rights issue. I would like to give a reference to Paris Convention. As you do know, at the end of last year, Turkish Grand National Assembly adopted Paris Convention, and now Turkey is a party to this convention. In the preface, it has been stated that the parties will prioritize human rights, indigenous people, local people, people with disabilities, and vulnerable people, and for the empowerment of women, and for the justice among generations. There should be special attention paid attention to those issues, and in line with these rules, the mitigation actions should be taken. Of course, there are lots of other topics that have been touched upon on that convention, but we do see this on the preface, and unfortunately, we are not seeing lots of action in this perspective. Many issues are on our agenda about climate change migrations. Surely, drought and food crisis will follow one another, and those will all contribute to major human rights issues. And in Turkey, as you do know, we have a new development ministry has amended its name, and the climate change has been added to the ministry's name. Now there is a presidency for climate change. That specific unit is working on this. In central bank, there is a unit established just specific to climate change issues. As you do know, EU has certain obligations within the scope of Green Deal, and we need to follow those obligations. And in Turkey, many companies, they have export and import relations with EU member states, and they need to follow those obligations and fulfill the liabilities. There was a climate convention gathered in Turkey, and in that convention there have been many topics discussed, and human rights is one of those issues, and gender was another topic highlighted. In Turkey, we do not have any climate lawsuits yet, but it is quite common in many other countries. We do see that, and in those climate lawsuits, the claim is not to have specific scientific issues. Scientific data is quite important to have, and also human rights violations are another topic of these climate change lawsuits, as it has been stated by the head of TİHEK. In action plan of Turkey, there have been highlights in regard to climate change and human rights. For the European Court of Human Rights, there is now a trend to people have their applications to the European Court of Human Rights about climate change, and especially migration, climate change, and human rights are the core of those lawsuits. Yes, it is hugely important to discuss, and I would like to thank you for allocating such a pressure, such a time to discuss this issue. We cannot say that it is not my topic to discuss. It is a topic that matters to everyone, to next generations, to our planet Earth. And by concluding my speech here, I would like to thank everyone for their participation, and I do wish a very successful session. And now I would like to proceed with my moderator role. I will introduce our speakers. The first one will be Nuri Özbağdatlı. In UNDP projects, we are collaborating with him. He is such a precious speaker. He has lots of valuable studies as well. He is the Climate Change and Environment Portfolio Manager in UNDP. In 1990, he started his career as a bird observer, and then he proceeded to the project management in regard to climate change and habitat. Then he has collaborated with NGOs to build their capacities, water and environment policies, EU, EQUI, and also in energy and climate change. He had lots of projects. EU bird and habitat directives were also among his work area. In public sector, in private sector, and in NGO, he has lots of collaborations to perform such projects. And as I've stated, now he is managing the climate change and environment portfolio of UNDP. He is in Turkey office of UNDP for the mitigation of climate change impacts. Now I would like to leave the floor to him. Thank you. Thank you, Professor Süheyla. Hello, everyone. I am glad to have this opportunity, and I would like to thank to TİHEK and organizing committee for their kind invitation. For the climate change, I will touch upon some different issues other than Paris Convention or mitigation of greenhouse gases, etc. Why climate change is and creates an inequality. This has been acknowledged as an inequality crisis within the scope of UNDP studies because here the individuals, societies, and the ecosystem that we are living in are questioned for their resilience. And in UN's Sustainable Development Goals, there are certain issues directing us for a successful and livable future. While discussing this, we are always talking about that privileged world, and unfortunately, those privileges cannot be seen directly, and we do not have concrete things, and we do consume all those privileges very swiftly. We create an imbalance, inequality to the environment, to our planet Earth. We give harm to the environment while enjoying those privileges. Within this perspective, in our system, in this order, in this consumption days, unfortunately, we have experienced this COVID pandemic. And lastly, there was the abrupt wildfires that we have experienced in our country. In Kastamonu, there is a simultaneous flood ongoing. These are the impacts of climate change on the resilience of countries. And if we had a rights-based approach, we can talk about that. We have the right to clean air. And unfortunately, every year, nearly 7 million people die because of pollution. Right to clean air and human rights could be just evaluated together within the scope of climate change. And because of extreme weather conditions, millions of people have been displaced in recent years. And when we compare the number of those displaced people against the number of people who were displaced because of conflicts, we do see that climate change caused displacement 3 times higher than the conflicts. If there is a 2 centigrade more increase in the average heat, we will have limited access to fresh water. And if there is a 4 centigrade increase, then the limitation to the fresh water will be decreased by 60%. So we need to evaluate climate change with a rights-based approach. UN now has a resolution, and 47 in European Council there was a decision, and 47 countries have approved that. In UN General Council, there was a study and new resolution of UN Human Rights Council submitted to the member countries. I do believe that in July there will be the ratification adoption process of that UN resolution. All member countries have been submitted, so this covers all UN member countries, and if it is adopted, then this will be a tool to combat with the climate change. These rights are not given to us by any institution. Those are our natural rights by birth. However, through recognition of these rights, there will be opportunities to create mechanism for the implementation. And in UNDP studies, there are critical issues. And Mr. Head of TİHEK already stated the relation in between human rights and climate change, so it is quite important for us to focus on this. Lately, UNDP have prepared a roadmap, and UNDP local, regional, and global offices create a systematic to implement those practices. Of course, we have a legal framework and legislation support. And the other pillar is the support to be provided to institutions, recognition of those rights, acknowledgement of those rights, and the third pillar is the dissemination of information to people. People need to be aware of their rights, and especially for environment advocacy, environmental activism, there should be a capacity building effort. Yes, we do not see no written definition of environment advocacy. However, if you just relieve yourself from your duties at the institutions, then you will see that everyone is equal. Everyone has right to fresh water. Everyone has right to clean air and food. So in our works, we do pay attention to this particularly. The relation of humans with environment, with these opportunities will be shaped by these impacts. And how would it be in the future? How would those relations will change? And What are the actions of institutions for access to these rights that I have mentioned? By 2030, what will be the population of Turkey? What will be the role of women and youth in that population? What will be the employment situation, and what will be the economic development by 2030? Surely it is not just an environmental perspective, it is not just a financial economic perspective, but we do have a rights-based approach. And as UNDP Turkey, we are collaborating with Ministry of Environment, Urbanization and Climate Change, and we analyze the situation in Turkey, and we create a strategy for Turkey in the long term. And in addition to the time scale and location-specific plans, we have identified certain problems, and in order to have a resolution to those problems, we are trying to identify the tools to be used for by the policymakers, and what should be the implementation mechanism. For example, about climate change in the forest villages, we are placing solar panels in order to generate power, and this electricity generation creates an ease process for women for certain duties of them, both technically and economically. There is now an ongoing process. The critical issue is that while doing that, we need to just be cautious about the rights of women and youth. As UNDP Turkey, we have evaluated the situation. What would happen if Turkey invests in renewable energies only, other than fossil fuels? We try to understand the economic figures, and we try to understand what will be the distribution of those financial gains among women, youth, and men. So we are just clearing the situation. And while talking about all those, 5 years ago, we have experienced one thing. Büyük Nohutçu family were killed upon a lawsuit that they have filed against a mining company. And this year, we have there is a special report submitted to the Human Rights Committee. It was stated that there should be more details. And in Erzincan İliç, for example, in that mining area, it has been realized that fresh water have been contaminated with cyanide. Last week, this has been identified, and this is also an issue we need to discuss. What should be our pattern to just relate these topics? This is an important thing. One critical issue here is that in addition to the mitigation of those negative impacts, we need to have capacity building. We need to have legislation, and in that legislation, there should be infrastructure studies, access to news, access to information about environment. We have such discussions ongoing, and at that point, I believe institutions like TİHEK, other institutions, universities, civil society organizations have major roles, and in UNDP strategy for climate and climate justice strategy, we do believe that there should be an acceleration on the implementation for awareness-raising activities in individual level, in community level, and at country level. I would like to give a pause at this point, but I think we need to discuss it further. This is a very important topic. Thank you. Thank you so much, Nuri, for this nice speech. I would like to highlight a couple of things. In how can we have right-based actions on legislation? And you have mentioned a couple of legislative documents. There are lots of action plans and there are lots of commitments by the state, by the government. And indeed, I don't think we have further improvements in amendment because we have a very well prepared legislation. There is a draft effort ongoing. And no matter how well you prepare your legislation, the implementation is the crucial part. There could be rights-based violations, unfortunately. And indeed, there are lots of if there are so many commitments, so many legislations by the government, we do believe that there will be lawsuits against the infringements. And there will be lawsuits by citizens against the state to fulfill their commitments on those legislations. This is happening across the world, so that could be the thing in Turkey as well. Now we will continue with our second speaker. I am not sure if I do pronounce your name correctly, but Sociology and Comparative Croatian Studies were her bachelor degree, and European Studies were the topic of her master's degree. In 2000-2003, she was project coordinator in Human Rights Committee in Zagreb, and then after she was the chair of human rights activities in Zagreb. At this point now, she is in the Ombudswoman institution of Croatia, and she is still an advisor for the human rights protection to the Ombudsman of the Republic of Croatia. You do have 15 minutes allocated to you. Thank you. The floor is yours now.
Thank you. Thank you very much. I'm very glad to be here with you, and I'm also very glad that this topic is the first thematic issue that we will discuss from the human rights perspective here in Turkey. Thank you for the invitation. Well, I work as the advisor for the human rights protection in the field of environment protection to the Ombudswoman of the Republic of Croatia. But currently I'm also chair of ENRI core group on climate crisis and human rights. Therefore, I will shortly present firstly ENRI core group, if that is okay, just shortly, and then we'll focus on the work of the Croatian Ombudswoman. But prior to that, I would like to introduce the topic, to make introduction to this topic and to again highlight the historic moment that happened last year in October when UN Human Rights Committee brought two resolutions. One is a resolution that recognized the right to clean, healthy and sustainable environment, and the other resolution established Special Rapporteur on climate change and human rights. Special Rapporteur already started his work. He had consultations with NHRIs 7 days ago in Geneva and online, and in fact, many NHRIs were present. These resolutions are important because they recognize the environmental degradation and climate change, that they are interconnected human rights crisis. The most vulnerable groups are the ones that are most endangered and intensely affected. The next step after this resolution, primarily the resolution on the right to healthy environment, is to recognize this universal right at the General Assembly. Nuri was telling us about this step. But member states also are invited to act. In fact, member states across the world, more than 150 of them already had recognized the right to healthy environment in their constitutions and their laws, and Croatia is one among them. Now I will shortly introduce ENRI core group on climate crisis and human rights, which was established the last year on the proposal of German Institute for Human Rights, which is one of the most active members of this group. Today it has around 25 members. It's open to new members as well. They're mainly from Europe, but also outside the Europe, such as from Philippines, Colombia, and Kenya. Due to COVID pandemic, we did not have chance to meet in person, but there were many activities already already conducted. First to mention is the handbook that was produced by CL, that's Center for International Environmental Law and the German Institute for Human Rights. It's a handbook on climate change and human rights, the contributions of NHRIs. It was published in 2020. It's available online. Another paper was published last year by ENRI. It's a paper on climate change and human rights in the European context, again at the initiative of German Institute, but also the Norwegian National Human Rights Institutions with contributions from other NHRIs. It was developed in the context of Duarte case. ENRI has also submitted two third-party interventions to the European Court of Human Rights, first in the landmark climate case of Verein, Klimaszenarion, Schweiz, and others versus Switzerland, and other climate case, the second, Greenpeace Nordic and others versus Norway. And both interventions were led by Norwegian National Human Rights Institution in cooperation with ENRI Legal Working Group, Climate Core Group, and the second party intervention also with cooperation of Hungarian Ombudsman for Future Generations. Another activity is the symposium, NHRI symposium, which was held on the sidelines of COP26 last year. Also a lot of organizers. And finally, I will mention that ENRI has the observer role at the Steering Committee for Human Rights of the Council of Europe. And members of ENRI core group participated at 3 meetings of the drafting group on human rights and the environment. Currently, the text of the preliminary draft recommendation on human rights and the protection of the environment was discussed and reviewed, but ENRI and also the Advisory Council of Youth expressed support for a binding instrument in a written statement also initiated and presented by our Norwegian colleagues. Now let me focus on the work of Croatian Ombudsman for, in the field of climate change, environment protection, and human rights. Firstly, I have to mention that we are fully compliant with Paris principles and that we operate within 5 mandates, that it's classical ombuds mandate, NHRI mandate, national preventive mechanism, equality body, and the last one, the mandate for the protection of whistleblowers. It is the newest mandate. The concept of our work in the field of environment protection and human rights is based on application of human rights-based approach to the protection of environment and climate change. We recognized a variety of topics and aspects within these 2 fields. It is protection of environment, nature, and natural resources that we called protected areas. Climate change, sustainable development, pollution of the air, soil, and water, noise and light pollution, non-ionizing pollution, waste management, really different aspects of environmental degradation and climate change can be recognized. We also recognized interdependence of the protection of the environment and climate change with other fields, such as health ecology, civil protection, defense system, in relation to climate cases events that we already had, floods, fires, as well as other natural disasters. Also to spatial planning and construction, economy, transportation, agriculture, etc. We apply a human rights-based approach in our investigations of complaints that we receive from citizens and citizens' initiatives, as well as NGOs, and also we take our own investigations. In these investigations, we assess possible violations of environmental human rights, that is right to healthy life and healthy environment, which we have in the Croatian constitution, and ARCUS Convention rights that are access to information and participation in environmental decision-making processes, access to justice in environmental matters. We also apply a human rights-based approach when reporting to the Croatian Parliament and when monitoring the implementation of recommendations that the Croatian Ombudsman gave. Mechanisms that we use to address violations on human rights are issuing of recommendations, warnings, opinions, suggestions to the authorities at the national, regional and local level, both in individual cases and in annual and special reports to the government. Regarding climate change, Croatian Ombudsman applied human rights-based approach on two climate change-related events that occurred in Croatia. These are floods in 2014 and wildfires in 2017. They were both investigated on our own initiative and reported to the Croatian Parliament as human rights cases. The case of floods was reported in special report to the Ombudswoman on the human rights during the catastrophe caused by floods in eastern Croatia, but it was not accepted by the Croatian Parliament. Namely, Croatian Ombudswoman, in accordance with the National Ombudsperson Act, has the mandate to submit special reports on specific issues falling within its scope of work, especially in cases of more serious or extensive violation of citizens' rights, and climate change and its impact on human rights is definitely an issue of special interest. The case of fire was not presented in special report, but in annual report to the Croatian Parliament in a form of specific chapter. Both cases were again reported in the second special report, which Croatian Ombudsman submitted to the Croatian Parliament in 2000 and last year in February, and this report was accepted by the Croatian Parliament in June last year. So a year ago, and now we are in the process of monitoring recommendations that are issued in this report. I have more things to share with you. I hope my time, 5 minutes, okay. Excuse me if I will speak more longer. Let me share experience in regard to the case of floods. It was a catastrophic flood that came suddenly, and it was a climatic change event. It was a great rain period with highest measured amounts of rain and water waves. The flood also affected our regional countries, Bosnia and Herzegovina and Serbia. We had only 3 deaths. It's not only, there are 3 people, but it was a huge damage, and over 30,000 people were evacuated from more than 150 locations. Flooded municipalities were also the areas of special state concern with vulnerable population that depend on social welfare, and also mostly rural population with low level of education, and a population that settled this area after the war in Croatia in 1990s. 3 days later, after the floods, the government of Croatia declared a state of emergency, in fact, state of catastrophe. And it was the first time that this state was declared in Croatia. 2 weeks after the floods, it was not possible to go before because the region was flooded. Croatian Ombudswoman herself and her team visited affected areas, and we came to obtain information from people and to see how their rights were impacted. And also to provide them with information that could help them. These field visits were conducted every month in a 6-month period. It was our model of on-site monitoring of the impacts of floods on human rights of the affected population. Besides going to field visits, we were receiving written and oral complaints of the citizens, and also had numerous meetings with state representatives. And as the result, we had the special report, which I mentioned before. Recommendations were applicable for the case of floods, but also for other possible events that could occur after floods, and they did occur. And just to mention a few of them, to further invest into long-term and sustainable firefighting and civil protection systems, to improve social welfare system by standardizing human rights criteria for temporary accommodation, to improve access to psychological support and to primary health care, and to standardize human rights criteria for distribution of humanitarian and financial aid, and also for reconstruction.
Mrs. Sassen,
yes,
only
yeah.
2 minutes. You have 2 minutes.
Oh, that's enough, thank you. And also to improve access to information. We noticed that access to information was really endangered, and people were not very well informed what to do, and also to improve the access to free legal aid. We also recommended the government to write off the overhead costs of destroyed houses. That is a really concrete recommendation. And also not to forget the other people that accepted refugees because they had extra costs. After floods, the new Act on Civil Protection System was brought, and Ombudswoman participated in this procedure with recommendations. Few of them were accepted. I will not mention them now. Now I will finalize with the case of fire, which happened in 2017. It is the same year when fires were happening across Europe, and Duarte case mentioned is in fact based on wildfires that hit Portugal. It's a Portuguese case of Portuguese youth. It was also a climate change related event due to dry periods and heat waves. Fire entered the second largest city of Croatia, Split, and there were no deaths, but it was really a huge event that endangered population. They were defending their own homes without equipment and without knowledge. It was a miracle that nobody got hurt, and finally citizens gathered into an ad hoc civic initiative, and together with them we organized a public discussion in the Croatian parliament in regard to this case. Just to mention that that both cases show the interconnection of climate change with human rights, and that is right to life, right to health, right to clean, healthy, and sustainable environment, and all other rights that I already mentioned. They are again reported in this special report which has 19 recommendations which we are going to monitor. This is the special report from last year, and the first recommendation was given to the Croatian Parliament to declare environment and climate crisis. And that is what happened in November 2019. The European Parliament declared environment and climate crisis, and so far 23 national governments have declared it. Some of them are from Europe, such as Scotland, United Kingdom, Portugal, Spain, Austria, France, Malta, but also Canada, Argentina, Bangladesh, South Korea, Japan, New Zealand. Croatia had not declared it yet, but it's our first recommendation for the special report, and we will monitor it. Thank you. Thank you. Sorry for much information.
Teşekkür ediyoruz bu kapsamda.
Thank you very much for this comprehensive, nice presentation. We have acquired important information regarding the practices in Croatia. If you have questions, of course, they can be answered later. We have limited time. Our third speaker will be joining online. She is not here with us. I think we are connected to her. Nina Eşke. She is a researcher and policy advisor at the German Human Rights Institute, and she has been working in environmental issues and human rights. She worked at UNDP and German Development Agency. She has degrees in economy, international relations, and human rights. You have 15 minutes.
This kind introduction. And first of all, I would like to thank the Human Rights and Equality Institution of Turkey for this opportunity to share with you today the work of the German Institute for Human Rights in the field of climate change. I will also share some of the challenges we have encountered in this work and also the needs we see for ourselves, but maybe also for other NHRIs to enhance their work in this field. I have prepared a short presentation, which I would like to share with you. I hope you can see it. Before I dive into what German Institute has been doing in the field of climate change and human rights, I would like to share some quick facts about the institutes with you. The Institute is Germany's NHRI since 2001. So last year we had our 20th anniversary. The Institute has A status according to the Paris Principles, and we have a legal basis in German law. Our mandate is to promote the integration of human rights into domestic and foreign policy decision, and we also monitor the implementation of international human rights treaties in Germany. Unlike some other national human rights institutions, we don't have a mandate to handle individual complaints or to initiate investigations into human rights violations. So that's a difference in mandate we may have compared to other NHRIs. So how do we fulfill our mandate? We use different working methods to do that. We monitor the human rights situation in Germany. We engage a lot in policy advice. We do interdisciplinary and application-oriented research. We are very involved in human rights education, and we cooperate with national, regional, and international human rights bodies and organizations. So now on the work of the German Institute for Human Rights on climate change, we really started diving into the subject in the year 2017, 2018. And first we began with awareness raising. So unlike today, 5 years ago, there was not really an awareness about the nexus of climate change and human rights. So that was the impression we had in Germany. So we started by providing information about the link human rights and climate change, the negative impact climate change can have on people's human rights. We participated in parliamentary hearings to share this information with the political decision makers. Now that awareness is there, I mean, one reason is that Germany has been hit by the consequences of climate change very badly last year with the bad floods we had where over 200 people died in Western and Southern Germany, but also with regard to the heat waves that we are also experiencing in Germany also this year. So we started with awareness raising, and then we moved on to policy advice and lobbying. And we decided to start engaging with regard to what norms are set at the international level. So in the climate regime, the Paris Agreement. So we started before every COP, Conference of the Parties, that take place once a year. Last year that was in Glasgow, COP26. We provide recommendations. We provide recommendations on how human rights and the human rights-based approach can be brought into negotiations and then actually be set in decisions that are made at these negotiations. So we provide recommendations, but we also engage with relevant ministries. In Germany, that's the Ministry of Foreign Affairs, the Ministry of the Environment, and the Ministry of Economic Cooperation and Development. We also start engaging in policy advice and lobbying with regard to relevant international processes. And my colleague Maya already mentioned the big success of last autumn, where the Human Rights Council recognized the human right to a healthy environment. And we are awaiting currently that recognition from the UN General Assembly, hopefully this summer. So there again, we engaged with the relevant ministries. We wrote policy briefs explaining, what that human right to a healthy environment involves, and that it is really an important step to recognize this right to for the work and to protect human rights with regard to environmental degradation, climate change, and loss of biodiversity. We also, especially last year, as we had general elections in Germany, very much engaged in national climate policy making and climate policy measures, especially with regard to the new coalition government. We provided a lot of input to the coalition agreement, and quite a lot of the things we advised on and provided for, we actually found in the new coalition agreement. What else do? We cooperate with relevant non-state actors at the national and international level, so non-governmental organizations like the Center for International Environmental Law, that was already mentioned earlier as well. And we also cooperate with the Office of the High Commissioner for Human Rights, with the Department on Environment and Climate Change. Recently, we also started doing more research into the topic. Research is important to gather data and facts to actually have something to advise on. So very, very recently, we published a study on human rights risks and climate change mitigation adaptation measures. So climate change, or the consequence of climate change, don't just have a direct impact on human rights, on people's human rights. They can also have an indirect impact on human rights with regard to the measures that states take to mitigate or adapt to the consequences of human rights. So these measures can have negative human rights impacts. In recent years, reports have been popping up, for example, with regard to forced evictions, with regard to renewable energy projects, for example, in Latin America, where people were forced to leave their land, so there could be built hydropower projects or wind parks or solar parks. So that's a study we conducted very recently, and currently we are also dealing with the subject of an enabling environment for environmental human rights defenders and climate activists in Germany. That idea we came up with, or was kind of pointed to us because the UN Special Rapporteur on human rights defenders last year published a report on climate activism and human rights. So for us, that was really a topic, as we have a very active climate activist scene in Germany, to start looking into this subject further. And then, as was already mentioned also by my colleague Maya, is we are very active in the ENVI core group on climate crisis, and we are also a member of the Gundry Caucus on Climate Change. So the Global Alliance of National Human Rights Institutions established a caucus on climate change last year, where NHRIs from all the world regions are members, and we recently we recently agreed on a work plan, and that's a really, really important development because it provides a forum for NHRIs at the international level to share good experiences, to do joint activities, for example, statements for the UN Human Rights Council, and so on. So that is kind of the work we have been engaging in at the German Institute for Human Rights in the field of climate change and human rights. What challenges have we encountered and how did we try to approach them? So when we started working on the topic of climate change, environment and human rights, we quickly realized that at the German Institute, and I think in most NHRIs, we are foremost human rights and not climate or environment experts. So we didn't really have expertise in how the climate regime, and when I talk about the climate regime, I mean UNFCCC, the Paris Agreement, and so on and so forth. How that works, what actors are involved, what are the processes. So we didn't have that expertise. So what we did, we tried to gather that expertise, and we did that by starting cooperating with relevant climate and environmental actors at the international and at the national level. So we cooperated with CL, as mentioned earlier, and OHCHR, and at the national level, we really engaged with established climate and environmental and non-governmental organizations, think tanks, and research institutions. Another challenge we encountered, and I think that's probably similar for most NHRIs, is that we always have limited resources. Limited resources is a big challenge, and we also had that challenge within the field of our work on climate change and human rights. So we decided to prioritize and to be explicit. So we started by looking at what are the key topics on the political agenda, what are political priorities, what are events that are coming up, like the Conference of the Parties, the COPs, and we really try to provide our policy advice and recommendations really explicitly on key agenda items to make political decision makers listen. We also took the approach to identify like-minded political actors and to find entry points for our work. So in Germany, the like-minded political actors we found before the general elections was the Green Party. I mean, they are very much active on the topic of climate change and also human rights. Luckily, they are now in the coalition government. They are one coalition partner. So for us, that's a really good opportunity to push human rights-based approach to climate change and environmental matters further. And we also, to gather expertise and to really use the limited resources we have efficiently and effectively, we started engaging in cooperation projects with universities, NGOs or think tanks to explore specific thematic areas. The field of climate change and environment, it's huge, it's vast. There's so many topics within this big topic, so we can't work on everything. But if we find cooperation partners that are specialists on certain specific thematic areas, we try to cooperate and engage with them. One example is currently we want to look more into the field of biodiversity, as biodiversity we see is now one measure or one field that is more and more seen as one instrument to combat climate change. So we see that the different fields of environment, biodiversity, climate change, they start to become closer and to be more connected. So we also try to keep up with that and gather expertise in these different fields. So what are the needs to enhance our work on climate change, environment and human rights, but I think also for other NHRIs, these needs exist. So one big thing, and that was mentioned earlier by the colleague from UNDP, data and facts. We need data and facts. Who is particularly affected by the negative consequences of climate change? Which population groups? Which population groups need the biggest protection? Where do we have to implement certain measures to protect these people? We get that through data and facts. And Data and facts always help to make political decision makers listen. That's our experience. So that's why, for example, we conducted the study on the human rights risks and climate change policies and measures that I just mentioned. What else do we need? One core function of Energize is to monitor and report on how their country actually implement or fulfill their human rights obligations. So we need a good methodology for monitoring and reporting on state climate action. We are very keen to develop such a methodology favorably in cooperation with other NHRIs. So that's one project we want to pursue very, very soon. And such a methodology is important because we gather information that we can use for policy advice and lobbying at the national level, but also we can use this information for reporting to the international human rights system, the UN treaty bodies and the state review procedures, and also the Universal Periodic Review to provide information to these mechanisms so they can assess whether, in our case, Germany is actually fulfilling their human rights obligations with regard to climate change and the environment. As I mentioned,
last 2 minutes.
That's perfect. I'm already done. So as I mentioned, we are also currently trying to build up expertise in related thematic areas like biodiversity, but also in the field of business and human rights with regard to climate change and environment relating to business activities and what obligations businesses or responsibilities businesses have with regard to this. Then we are still, and that is a task that is always there, is to build and deepen alliances with the climate and environment community. As I mentioned, we need this community to actually implement human rights-based approaches on climate policy making and measures, but we also need this the expertise of this climate and environment community, because certain climate measures might be really, good to combat climate change and to adapt to climate change. But as I mentioned, some of these measures bear certain human rights risks. And so it's very good to have close cooperation between these two communities. And last but not least, pooling resources, sharing information and best practices. I mentioned the Gundry Caucus on climate change. We are very happy that that caucus exists because that is a very, very good forum to actually share information and pull the limited resources NHRIs have to advance and enhance our work on climate change and human rights, and also NHRI working groups at the regional level, in our case, the Gundry core group on the climate crisis. So, and that's it. Vielen Dank. Thank you very much for your attention.
Mrs. Eşke, thank you very much. Excellent presentation. Üç konuşmacımız da bitirdi.
So our 3 speakers have concluded. Thank you for your valuable contribution. Before giving them the floor last time, do we have any questions? Thank you very much. My question is for all 3 speakers. You mentioned that creating the financial resources and bringing together our knowledge is important. As a legal person, my question is about the allocation of financial resources. I know that we all agree about that, but in allocation of the budget, the parliaments have the right to say, and the courts cannot intervene with the decision rights of the parliaments. Of course, there are rights and there are demands, and by protecting them, can we reach our goals? Ms. Ece asked all three questions. As a legal person, I would like to touch upon how the traditional courts approach this issue. And environmental law is a bit different from the conventional principles and rules of the conventional court approach, but the courts in Turkey have not yet differed themselves from this conventional approach. And in terms of budgeting, our administrative courts can only review what the administration do in terms of their administrative obligations. So they cannot review how the budget is related to their actions. This is not their mandate, since the plans, the development plans are only suggestive plans and they're on recommendations. So there's no obligation for realization, and I don't think courts will be involved in reviewing these reviewing the implementation of these suggestions. 5 years ago, there was a court case against a nuclear power plant, and the court decided that it is not in their mandate to review the political decision of the state, the government. But as you mentioned, the allocation of budget lines is not a judicial decision. It is an administrative action. So I don't think courts will be involved in reviewing the allocation. And how about our speakers? Would you like to make any comments? Thank you. Any other questions from the floor? No questions? Okay, then we will have a lunch break. Our speakers, would you like to make any last comments? Thank you very much. I know it's a bit late, but I would like to touch upon one more thing. In 1950 in Stockholm, there was a Human and Environment Conference of the UN. And the definition of eco-genocide was made at this conference, so how the environment was devastated. And at another convention, we also touched upon eco-anxiety. When we see what is going on with the environment, we have an anxiety. If we don't evaluate the issue of climate as a human rights issue, when we are living in a city where the environment is protected, we can create a world where women are treated unequally and the rights of the child are not protected. So we should not separate these two concepts from each other. And in order to achieve this, there are good and bad examples, but we can learn from both. And if we learn and if we approach equality, then we will reach the goals of our country, and with the right to nature, and we will be living in a country where equality exists.
The question and to give some information, well, Croatia has not yet good results in environmental case law, unfortunately. And one of our recommendations was to have education of judges about environmental protection and climate change. That is really important. And also, as I stressed in my presentation, our NGOs, environmental NGOs, they claim that the access to justice is denied to them. They have serious problems, mostly of financial nature. If they lose the case, they have to pay, and this has to be improved.
Teşekkürler. Mrs. Eşke acaba?
Thank you. Do we still have Nina Eşke? Is she online? I think she is gone.
No, I'm online. Can you hear me?
Okay.
Hi. Yes, no, I'm still online.
Would you like to say anything?
Yes.
Would you like to say anything? Last word?
Yes, I would like to actually address the question that was posed about budgeting. I mean, it's true that courts don't have a competency to decide on this, but I think in Germany we had a big decision last year from the Constitutional Court, where the court found that the climate goals Germany has set themselves, or they're missing climate goals beyond 2030, and that is important to have these goals with regard to the young and future generations. And they also said there is a need for adaptation. So for us, we take this ruling and for our lobbying and for our policy advice, and to also say that the German government has to invest resources, there we are with regard to budgeting, to fulfill the decision by the court. And I think here is a big role for NHRIs, but also for other non-political actors within each country to lobby for this. And also, I would like to point out that the UN Committee on Economic, Social and Cultural Rights in 2019 published a statement where they said that the state has an obligation to invest all its available resources to fulfill its human rights obligation with regard to climate change and human rights. And one last point for that, we need, as I said, data and facts. So when we know who is most affected by the negative consequences of climate change, disaggregated data, we can use this to then look at how the government is budgeting and where the money is going and where the money should be going. So that is, I think, that it's the task of lobbying and policy advice of NHRIs and also non-governmental actors. Thank you.
Teşekkürler.
Thank you. Esteemed speakers, thank you for all your valuable contributions, and I hope their contributions were helpful for you, all participants, and I would like to thank the institution for giving us this opportunity to discuss this important issue, and I hope their efforts will continue. Thank you, all speakers and our moderator. I would like to invite Professor Dr. Muharrem Kılıç to here for Blake Award.
esteemed participants, now we will have our lunch break. We will start the next session at 2.
Ses deneme, ses prova. Ses deneme, ses prova. Say, hey. Hey. Say. Ses deneme, ses prova. Ses deneme, ses prova. Ses deneme, ses prova.
Bir prova test. Hey.
our moderators to the session. We will have first Professor Dr. Engin Yildirim as the chair. Aynura Bekanova will be our speaker, and we will have online participant Daniel Morris. First of all, hello everyone. Welcome to the afternoon session of this international summit organized by TİHEK. And I think this session is important because it will be about business world and human rights. It is not well appreciated so far, and I would like to thank TİHEK for this topic. I am following this topic very closely. I'm trying to catch up with the literature. That's why it is also a personal interest for me. Without further ado, our first speaker will be Aynura Bekanova. She is from UNDP Europe and Central Asia Regional Office, and she is a policy expert in regard to supremacy of law, security, and human rights. And I would like to leave the floor to her for the presentation. The floor is yours, ma'am.
Thank you very much for your kind words, Mr. Yildirim. Distinguished participants and guests of the International Summit, ladies and gentlemen, please allow me to begin by thanking the chairman and the members of the Human Rights and Equality Institution of Turkey for hosting this important and timely event and allowing us at UNDP to talk and provide our insights on business and human rights. Let me start by explaining our work, and I think I have a presentation to be shown. Here we go. Yes, so we have been working as UNDP in advancing the agenda of business and human rights since 2016. Wherein we started from setting up a regional program in Asia, but by now we have expanded to all regions across the globe. Our main goal is to support countries to adopt a comprehensive approach to human rights and responsible business conduct based on the UN guiding principles on business and human rights. Therefore, we work very closely with UN Working Group on Business and Human Rights. We also work with OHCHR, ILO, OECD, and other stakeholders. The map that you see is currently showing our engagement in 25 countries with specific business and human rights projects. And in our region, specifically in Eastern Europe and Central Asia, we are working in Turkey, as you know. We started our new project. We are also working in Kazakhstan, Kyrgyzstan, Ukraine, and most recently, we would also like to start working with Azerbaijan. So let me share today the insights from our latest regional study that we have conducted on business and human rights, when we wanted really to understand what are the latest status of implementation of guiding principles on business and human rights in all 18 countries that we cover. That's why you can see the geographical coverage of our office. It includes Central Asia, South Caucasus, and Western CIS, the Western Balkans, and Turkey. So we examined the cross-cutting trends and challenges which are driving the business-related human rights violations and provided recommendations for how to advance this agenda. The study was prepared by our regional experts. We had a team of regional experts on business and human rights, and the methodology included interviews in all countries, data collection, desk review, and so on. So the study is currently at the final stage of being publicized. It will be out very soon. And I'm happy to share with you the major, let's say, findings of this study. So what we have learned? We have learned that the key causes of business and human rights related violations in the region include major 6 factors. The first of all is the presence of corruption. As you know, the corruption has a significant impact on human rights, especially when it comes to business and commercial interests. So when the governments do not hold businesses accountable to their violations, this creates conducive environment for further business and human rights violations. As an example, in Ukraine, for example, during COVID times, there were cases when several high-profile companies, large companies, illegally obtained permits to work during quarantine, despite the imposition of bans. And this is one of the examples where the state then has not been taking appropriate action. Another factor that is very much characteristic for our region is unaccountable state-owned enterprises. We have many state-owned enterprises in key sectors of economy of our countries, especially in energy, construction, as you know, mining, extractive industry, and so on. And they are of strategic importance of governments, as we understand. But the scrutiny over their human rights record should be also appropriate. And there are currently being developed different guidances for this kind of state-owned enterprises by several entities like OECD. But it's important that civil society and states also hold accountable and work on this area. The lack of legal protection of labor and trade unions, as you understand, the biggest chunk of business human rights violations relate to labor rights. We see that these trade and labor unions are special actors that provide legitimate representation of workers to uphold and protect their rights and freedoms, but they also guarantee social protection and the dialogue. And we see that they are often not granted sufficient legal protection to be able to authoritatively advocate for the interests of their members. Sometimes they face persecution and pressure by businesses and the governments. And I would like to mention here a very good example from Turkey, when Ethical Trading Initiative built a local platform of 30 brands of retailers, employer associations, trade unions, that provides space and dialogue on business and human rights, and we hope this will be expanding to further. State capture by business interests, this is another factor that we are seeing. It's when there is an entrenched oligarchic control over business and governments. We see that these powers often unite in their position to improve the labor standards and significantly weakens the influence of investors who could actually come to the country and contribute to the implementation of business and human rights standards. Informal employment in our region constitutes more than 50% of the workforce. And as you know, because of this unregulated nature of this economy, there are many issues related to lack of social protection, coupled with dangerous and exploitative working conditions. So many informal workers are vulnerable and unprotected. But what we are seeing is an interesting trend that the informal workers are starting to create associations and trade unions to collectively protect their rights and interests. And hopefully this trend will turn into a bigger pattern. And the last one is a weak rule of law in state institutions in our region also contributes to violations in business and human rights area. As you know, most of the countries have already legislations in place which formalize the standards on rule of law, and most of the countries actually ratified the treaties and international conventions on human rights. However, as we discussed today, the norms have not been yet translated in some cases into the practice due to various issues related also to politics and lobbies by certain businesses. So while these are the factors, I wanted also to share with you the information about the common business-related human rights abuses that we see across all 18 countries. I want to mention that this is not just for Turkey, what I'm speaking about, it's across the region. So obviously the situation in Turkey is probably different or more specific. So the violations of labor rights of workers, as I said, is one of the biggest areas of concern. Lack of guarantees of occupational health and safety, especially in the industries like mining, agriculture, construction, and the metallurgical industry, forestry, and even fish farming, we are seeing that there is not sufficient protection of workers. Forced and child labor, we discussed a lot this. Restrictions on the freedom of associations, mostly the associations of workers. Violations of minimum and living wage legislation, human trafficking, and environmental degradation. Today we spoke about the climate change and environmental justice, and indeed we are seeing a trend where there are more and more cases being let's say, reported and raised, especially in Western Balkans. We have, for example, in Serbia, there have been a protest in April 2021 when thousands were gathering to protest against the construction of the new lithium mining because of the environmental impacts that they were considering will be negative and human rights impact negative for the local communities. And because of this protest, the Serbian government revoked licenses for this project, and has been more diligently considering the requirements for this kind of construction. Some other issues, I would like to mention violations of land rights, enforced displacement, prosecution of human rights defenders. We are also seeing a lot of pressure on civil society, and the gender discrimination in the workplace, especially women, face discriminatory laws and often are underrepresented in the workforce, but at the same time overrepresented in gender-segregated, lower-paid jobs. The most vulnerable groups that are affected by business and human rights violations include the persons with disabilities, migrant workers, children, LGBTQI, refugees and internally displaced persons, Roma people, people living with HIV, but also ethnic and national minorities. And I'm not going to speak about the scope of grievances and complaints because of these groups, because as NHRIs, you're probably much more aware than even I do about the grievances that come to your mechanisms. So I just wanted to mention, in particular, the case of persons with disabilities. We see that they continue to face a lot of discrimination in terms of their access to employment, education, and social services. But there are many good practices as well. And here I would like to mention Azerbaijan, Belarus, and Kazakhstan and Ukraine, for example. They have laws that have mandated a quota for employing persons with disabilities. Because these groups is usually not competitive at the labor market because of the lack of education, professional or secondary, the employment opportunities are very limited. And also Georgia has a system when the state provides a 50% subsidy for salaries for an initial period of 6 months for persons with disabilities employed in the private sector with the requirement that then the company extend this contract for another 6 months. So these are some interesting examples. And on the child labor, of course, we are very much aware about a huge effort that is being undertaken by Turkey. For example, Fair Labor Association, we know that works in hazelnut sector, is trying to address the cases of child labor. And Kazakhstan is also very active now, carrying out a nationwide campaign, putting pressure on farmers so that they increase due diligence measures, and for example, when they pick up the workers, they verify their age prior to transporting them to the field, and also arranging squads, including several local authorities and civil society to check that. LGBTQI, I mentioned also under pressure. There are some legislations, very good ones in Western Balkans, but the practice is yet to be seen, and also ethnic minorities and Roma, the more probably could be done by international companies in particular. The next slide is really on the status of the progress in terms of policy by national governments, and here I wanted to show that there are some promising developments in state policies. Two countries, Georgia and Ukraine, have brief sub-chapters in their national strategies on human rights, and also have developed so-called national baseline assessments when they looked at the status of business and human rights in their countries. I know that in Georgia they are now at the stage of developing a new human rights strategy, and we hope to see, as we were told, to have an additional chapter in this regard. Civil society in many states also, like Bosnia-Herzegovina, North Macedonia, Kazakhstan, Ukraine, and Serbia, have actually developed their own assessments on business and human rights. But in most of the cases, they have not been yet adopted by their governments. So we really would like to see more uptake of this work at the level of states. So the conclusions are here that most of the states are yet to develop national action plans on business and human rights and conduct their national baseline assessments according to the methodology which we have been adopted, and we'll be happy to share them with you. And in this regard, of course, we will also continue conducting the regional advocacy and awareness raising. And we have actually every year the regional forums where we bring the regional authorities together to discuss these issues. This year we will have it at the end of October, and you will be all invited. Another, I think, big changer for the region is, of course, the upcoming EU directive on due diligence for businesses. It both includes the requirement on human rights and environmental due diligence. And once it is adopted, it will have a spillover effect on our region, because the businesses will be required that operate and associated with European markets will be required to have this due diligence in their work. So maybe more related to the work of NHRIs, we also created a brief overview of the access to remedy, because this is the core work of the NHRIs. And our conclusions are that while the rights holders, of course, always have access to judiciary to resolve their complaints related also to the conduct of businesses, unfortunately, there is not much effectiveness yet, and European Court of Human Rights so far has delivered, hundreds of judgments related to the violations of right to a fair trial, so more yet to be done. But what we've seen is that most of the national human rights institutions are actually very much trusted state bodies. From our interviews, that we've seen that people also sometimes prefer to go to NHRIs rather than judiciary at first instance. So the problem with NHRIs, as we see, is that not all of them have jurisdiction and mandate to actually examine complaints against private sector. As the result, they do not have possibility to investigate alleged business-related human rights abuses. Only some of them have this direct mandate, like, for example, in Republic of Moldova, the public defender has this mandate to directly address complaints against companies. But most of the mandates have, of course, a possibility to work on research and human rights awareness raising. And there are also other grievance complaints-related mechanisms that exist within the companies, but mostly within the global companies, because of course they have resources and or subsidiaries of these global transnational corporations, but they are very few. And also in our countries, we have so-called OECD national contact points that consider complaints against businesses. They are located within ministries of economy investment portfolio, but they unfortunately only in 3 countries in our region, which is Kazakhstan, Turkey, and Ukraine, and we hope to see them more. So this is really the recommendations to the countries, to governments, to businesses, and civil society. I won't stay here long because I think it really needs more time to explain this in detail, but we have developed this throughout the report, and I'm happy to share much more essence of it. I wanted to focus on this one, on recommendations to the NHRI specifically, which are also very generic at this point, because I expect that the next speakers will give you more understanding and more information about what NHRIs can do as regards to guiding principles. But from very regional point of view, we would suggest that NHRIs expand their activity in business and human rights as much as they can, and either on its own or in collaboration with the partners like us, but also European network of national human rights institutions, and also with the companies. We also suggest NHRIs to speak to their relevant authorities, government authorities, to help them expand their jurisdiction and mandate so that they will be able to cover complaints against business and private sector, and have more resources to build their own capacity. And the last slide is really more about our work. As I've mentioned, this is the regional perspective. We are working on supporting implementation of national action plans in Georgia, Ukraine. We are also working on baseline service, and Turkey is now being included in Ukraine, Turkey, Kazakhstan, and Kyrgyzstan. Jigdem, who will speak after me, might speak about this assessment that she has done. And as I've mentioned, we are holding every year the regional platforms for discussion where we invite also NHRIs, so I hope to see you all. And lastly, we now launched this year, very fresh start, these programs on business and human rights in these 4 countries, which is Ukraine, Turkey, Kazakhstan, and Kyrgyzstan, but we really want to expand and see more. So these are my contact details. I'll be happy to respond to any of your questions. Thank you for your attention.
Bilgiler için teşekkür.
Thank you so much for all the information. The questions and answers will be delivered at the end of the session. The next speaker will be an online participant, actually.
Merhaba, hoş geldiniz.
Hello, welcome.
Merhabalar hocam, nasılsınız?
Hello, esteemed professors. Prior to your presentation, I will give brief information about your CV. Çiğdem Çimren is a lawyer with a PhD degree, and she is the founding chair of Minerva Business and Human Rights Association. With her experience on the field, she is focusing on agriculture and textile sectors. She is providing consultations to this sector about human rights implementations. The floor is yours. Can you hear us? Yes, yes, indeed. Thank you so much for your introduction. As I am participating from Zoom, I am also hearing English interpretation, so it is a bit confusing for me. I will be sharing my screen if possible. Could technical team assist me? Thank you. Hello, everyone. I really wanted to be there with you. However, I had to be in Brussels because of a meeting. Though I'm not there physically, thanks to the technology, I am able to participate to this important international summit, and I am glad to have this topic in the summit. I would like to thank the Human Rights and Equality Institution of Turkey. I would like to thank the esteemed head of institution and esteemed professor. I would like to extend my best regards to all of you. Another request from technical team. If possible, could you please mute English interpretation? I will introduce myself first. Indeed, I will be talking about Minerva. Minerva Business and Human Rights Association is a recent association, and indeed we have established this association with lawyer Pınar Kara, who is a specialist on private business, and our main goal was to have an independent civil society organization conducting its business to encourage fair practice in business world, and we wanted to fight against child labor, and we wanted to remind business world their accountability and their responsibility to conduct their work in line with human dignity. And we do highly appreciate the dialogue between business world and human rights advocates and government. It is crucial to have such a collaboration in order to have fight in this field. We are a recent association, surely, but we have ongoing activities. In textile and in agriculture sector, we had a project to prevent child labor with UNDP and with ILO. We have conducted a project, and as we have an academic background, we do follow all the developments. And unfortunately, in Turkey, we do not have an in-depth literature, and we do try our best to contribute with academic reports so we can get to know Turkey and we can introduce Turkey to the global arena in this field. My topic will be in two sections, actually. Yesterday we were with Alp Bey from TİHEK, and we had an opportunity to have a chat in this topic. I will try to just identify international organizations working in business and human rights, and then I will try to take a point of view from the perspective of global associations and TİHEK. I will have some humble recommendations. International human rights organizations are established with the purpose to protect and strengthen human rights. Maybe you have already touched upon those issues, as there was some other sessions, so I am quite sorry if I'm repeating it. But we have Paris principles, and we have international conventions since 1990s. GANRI has accreditation process, and as far as I do know, TİHEK is in intense efforts to have the accreditation from GANRI. Hopefully we will have this quite soon. For the protection and improvement of human rights, there are organizations, as I've stated, and those organizations have important roles for business world as well. This has been accepted, acknowledged lately. Especially, there could be state-caused human rights violations, but when we say business and human rights in the last, nearly for the last decade, there are certain activities to identify. Now, colleagues do try to resolve any human rights violations caused by private sector, and the organizations to take a leading role to identify those problems. And this led us to a stage. This independency is not just to the state, but also there should be independency from business world as well. I hope you can see the slides. As I've stated, in 2011, UN Human Rights Council identified certain principles, guiding principles for business world within the context of human rights. The first one is protection. Conventionally, it is the duty of state to protect human rights of people. And states are parties to international conventions. Those duties are interpreted from those conventions, surely. And within the scope of business world's violations of human rights, what are the things that the governments can do? These guiding principles provide answers to the possible solutions.
Yani uluslararası metinde yeri almayan farklı farklı nedenlerden dolayı
With several reasons, those
sorumluluğu şirketlerin
responsibilities are not
sadece sorumluluk olarak orada da bir sansürlük kullanılıyor.
stated on the international conventions. There are responsibilities. In the first place, we have stated that there are duties of states, but corporates have responsibility to show respect to human rights. So we do see there is a leveling here, hierarchy of the approach. And we have remedial solutions whenever there is an infringement of or violation by the government, and if the government was not capable of protecting it, then remedies will be in place, and it guides us with the provisions stated in that guideline. In the guiding principles, as I've stated earlier, we have seen the activeness of international organizations. There are lots of references to the international organizations on those guiding principles. It says that, for example, it should be in line with Paris principles. Within the scope of the duty of state to respect human rights. And it tries to tell that while state fulfill its duty, it takes advantage of those tools. What do we understand here is that while having harmonization with Paris principles, in guiding principles, we do see that there are foreseen requirements to be followed. So I think we can say that TİHEK is a very young organization, and this is very exciting when we think that they could turn this into an advantage for their implementation. It will not be an easy process. It is not just for TİHEK, of course. All of a sudden, there will be issues about business world's violations on human rights coming to the national human rights institutions, and it requires technical information. This is a very particular, specific topic. It requires human rights knowledge, surely, but on the other hand, it requires information about supply chain, what is the economic situation, what kind of collaborations do exist in between companies? What are the impacts on environment? What are the impacts on humans? And what kind of different level of impacts could be observed? So this is quite complex. And in such a specific topic, these institutions need to deal with it, and it just creates a huge burden on their shoulders. In order to perform their duties at its best, they will try to do
standartlarda aslında
everything
o
to
ileriden
facilitate
eskiden biraz daha belki kısıtlı
the
bir
access of
bakış
people
açısından
to
ağırlığı belki orada
justice, and on the other hand, there are lots of international
tabii işte bizim gibi
regulations and a large scope to be informed. So this creates a threatening situation. As I've stated, the states, the business world has responsibility to follow human rights. It has been accepted in 2011.
However, there is a trend of continuing to perform these duties voluntarily. This is a discussion that dates back to 70s, especially in developing countries. Multinational companies are affected by the consequences, but until the UN identified the guiding principles, they were struggling. But the principles were not enough. It's not a magic wand, so they could not solve all the problems in this area. In many fields, people are forced to work under inhumane conditions, forced labor, and in Bangladesh and other areas, there have been environmental crisis, disasters. So since the 1970s, this process has been going on, and it has been led by the civil society organizations, but the efforts were not necessary. But we need sanctions and liability. So to achieve this, there have been legal initiatives in the countries, and they expect companies, businesses to respect these legal requirements, and there are different levels of voluntary action, and at some level they are liable by the laws in France. The law that was passed in 2017 is now showing its results, and the law that was just passed in Germany is yet to have an impact on supply chain. And now the businesses are reviewing their compatibility with human rights requirements. So there may be complaints in the future. They are taking measures. And this is the trend in the world. So therefore, global warming, the inequality of income, incompatibility of the businesses running with no care to the nature. These are all ongoing problems, and UNDP has been working in many countries to force this compatibility with human rights standards. So, for the compensatory remedies and other actions, national human rights institutions such as TİHEK have an important mission. In the countries that I have just mentioned, things were different before these laws were passed, and at UNDP and in our institution, this is very important, and we will be closely working with TİHEK. Of course, such laws don't come into the agenda by themselves. There's always a pressure from the civil society. So in drafting of such legal texts, national human rights institutions play an important role. They need to promote the state to draft a national action plan on human rights. And in other countries, we have seen a similar progression of this process. Of course, not only the national human rights institutions can do this. This is a comprehensive process, but they can lead the way. And under their leadership, national action plans can be drafted. The third pillar of the guiding principles is the access to legal remedy. People whose rights are violated can access legal remedies in internal remedies, judicial, administrative, or it can be an international remedy that goes to up to ECHR. And guiding principles explain the ways how legal remedies can be used. And the national human rights institutions can act as a part of the state complaint mechanism. So they contribute to solving of the complaints in line with the guiding principles. They can act as a remedy mechanism. But in human rights violations in the business world, the legal amendments can be used to eliminate the violations. And a legal amendment to make TİHEK, the national institution, to act as an institution for filing complaints in line with the guiding principles would be an important step, and that would make TİHEK an important component of the business world and human rights. When I talked to Alp yesterday, he told me that, of course, we have power in the area. We can apply pressure to the business world. In that sense, I think some people, especially the civil society, can act as whistleblower to the TİHEK. And I believe that civil society organizations can have very important roles. TİHEK cannot monitor everything by itself, but cooperation with other organizations can help at this point. Of course, the legal basis of this is not possible yet, but a legal amendment would help with the authorization issue. Could you please wrap up? Okay, this is my last page. I would like to wrap up here and come to a conclusion. Of course, we can go into more details, but I want the current capacity duties of TİHEK can be used to increase their field of performance. One of them is about the business world. More research can be done in order to increase the awareness of stakeholders. TİHEK can take up such a role, so including small and medium-scale businesses are important actors who have an impact on the economy, and their resources are limited. So a state institution should help them improve their stand on the human rights while being in compliance with these standards. Turkey has an important role in the world in terms of textile, automobile exports, and because of the recent laws about human rights compliance, their supply chain will be affected, so they need to comply with the legal requirements so that these small-scale businesses can compete in the international area. If we want to ensure fair
sonucunda ortaya çıkacak olan politika nezdinde ya da kanunlar nezdinde bütün herkesin, bütün oyuncuların
fair trade,
yargısıyla
then
aslında eşit
we
ve
must
bağımsız
support
yani
them.
herkesin oyun eşitlemesi önemli gözüküyor. TİHEK'in de devletle bu bağlamda çalışması, diğer ilgili
Change the rules of the game, and TİHEK must act as a contact point and supportive mechanism. TİHEK can also work in the field of building relationships and maintaining them with the other organizations. OECD is working with the Ministry of Industry, so they have a good working mechanism, and TİHEK can be involved in that cooperation mechanism, and it can bring positive results. Thank you. Now we are going to hear our last speaker. I would like to give you some brief information. Daniel Morris from Danish Institute of Human Rights. He is a consultant on human rights and business advisor, and he is the head of European Human Rights Working Group.
Mr. Morris, do you hear me? Mr. Morris, do you hear me?
Yes, I can hear you. Can you hear me?
Okay, let's move. Let's start. So the floor is yours. Actually, the virtual floor is yours.
Great. Thank you very much, and thank you very much for the invitation to speak to all of you today. I'm Daniel Morris from the Danish Institute, but also representing the European Network of National Human Rights Institutions, which has a working group on business and human rights and brings the national human rights institutions, the NHRIs, from across Europe, not just the European, not just the Council of Europe, but from the broader European region to talk about these topics. I just wanted to start by taking a step back and asking the question of why national human rights institutions are working on business and human rights. I think in the last few years, we've really seen a spotlight put onto some of the biggest issues of our time. The pandemic, for one, the need to procure personal protective equipment for staff and for people. We've seen drug companies work for the public good, but also their shareholders receive massive bonuses. With the economic effects of the pandemic, we're also now seeing a movement to build back better, which of course is focused on the way that businesses operate in our lives these days. And of course, we're also seeing now the next big challenge coming in the form of climate change and the climate crisis. All of these have businesses at the heart of the issue, while also having huge impacts on human rights. So businesses are really at the heart of human rights conversations today. And national human rights institutions, in our job as a watchdog in relation to human rights, I think have an increasing need to look at the role and responsibilities of businesses. The mandate for national human rights institutions to work on the issue comes from the Edinburgh Declaration of 2010. This is where the Global Alliance of National Human Rights Institutions came together to make a declaration which states how national human rights institutions should work with the topic, looking specifically at promotion, education, and research, also looking at monitoring, complaints handling, and mediation and conciliation. So that really is why NHRIs should work on this and provides a mandate for that. Of course, national human rights institutions have to base all of their work on established human rights principles and obligations. When it comes to business and human rights, there are a number of different frameworks, but the one that is central are the UN Guiding Principles on Business and Human Rights. While not creating any new hard obligations, they gather for the first time all of the other hard human rights obligations from conventions and treaties in one place. So while the principles themselves are not hard law, the obligations that the principles contain are hard law. And that is really useful for a national human rights institution, which has to base all of its work on hard law. Now, of course, the UN Guiding Principles have their three pillars: the state duty to protect, the corporate responsibility to respect, and access to remedy. And what I'm going to do today is walk through all of these three to highlight how national human rights institutions are already working on these topics. Of course, the UN Guiding Principles were established in 2011 and have since been endorsed by the EU, the Council of Europe, the UN, the OECD, G7, and a whole range of international bodies to show that they are the main framework to use on this subject. And of course, that means we have 10 years more of experience on how NHRIs can work with these. So the first pillar is the state duty to protect. And from a national human rights institution perspective, there are really four elements to this. The first element really is when the state enacts laws and policies. And one key role of national human rights institutions is to analyse legislation for compatibility and to see how it impacts and realises human rights. And we see a lot of NHRIs working to analyse how legislation, proposed legislation, touches upon business and human rights. And through doing this, you really realise how broad the field of business and human rights is, because a lot of legislation can touch on this subject, whether that is in relation to public procurement, for example, or whether that is in relation to the rights of landlords and tenants, or whether that is in relation to operational health and safety. All of these have a business element, and NHRIs around the world are engaging on these legislations and highlighting the need for businesses to respect human rights. Another big area of work for national human rights institutions is around inquiries. And we've seen quite a few inquiries conducted on business and human rights related issues. One of the key ones, one of the landmark ones, was done by the Australian Human Rights Commission back in 2016, where they looked at employment discrimination against older Australians and Australians with disabilities, looking at the practices and attitudes within businesses and laws that deny or diminish equal participation within Australian workplaces. Another key area is in relation to assessments and analysis. And national baseline assessments, which have already been mentioned today, are one key area that NHRIs can engage on. We've seen this really in Georgia, the Ombudsperson's Office working with the government and an NGO to produce an analysis of laws and policies related to business and human rights, designed then to highlight gaps which a national action plan was then meant to address. In Germany, the National Human Rights Institution is in the process of conducting a second national baseline assessment to inform their second national action plan on business and human rights. And national human rights institutions are in a perfect place to do this kind of analysis work because they're used to doing this kind of work in the past, but also they are a good body which can coordinate between government, civil society, and businesses and ensure that a human rights-based approach where participation is central to the processes. And then, of course, there are national action plans on business and human rights. And we've seen in Kenya, for example, the National Human Rights Institution take a key role in supporting the government in developing a national action plan. And we also see in France, the National Human Rights Institution given a key role in monitoring the implementation of the National Action Plan on business and human rights. And of course, a lot of these national action plans have specific action points for national human rights institutions. So it's quite important for national human rights institutions to engage with the government on these issues. The second area is when the state acts as a business or in direct relationship with a business. One area, for example, is export credit. And in Finland, we saw the Human Rights Centre conduct training for the Finnish Export Credit Agency on human rights and how to incorporate human rights into their export credit work. Public procurement is another huge area of work and a huge area where we can make an impact by integrating human rights into it. And the Danish Institute for Human Rights has developed guidance for public buyers on how to integrate human rights into all of the stages of the procurement cycle. Then, of course, we're seeing an increased incidence of businesses responsible for delivering essential public services. And we've seen a number of NHRIs engage with this topic. In the UK, they have held an inquiry into older people in private care homes. In New Zealand, the National Human Rights Institution has held an inquiry into the private transport sector and how that impacts people's human rights. Of course, there's also businesses which operate in conflict-affected areas, and I'm thinking specifically of Ukraine at the moment. There is work ongoing to try and articulate what business responsibility to protect human rights looks like in a time of conflict. In addition, we're seeing NHRIs engage on investment and sustainable finance. For example, at the European level, where new regulations and legislation is being developed, the European Network of National Human Rights Institutions is engaging on these to articulate and ensure that human rights are included within these new developments. In relation to Pillar 2, the business responsibility to respect human rights, there is a role for human rights institutions to explain to businesses what exactly due diligence is, both human rights and environmental due diligence. In Northern Ireland, they have a business and human rights forum where businesses voluntarily come together with the help of the National Human Rights Institution to discuss challenges and successes in this area. There are also national human rights institutions which engage directly with business associations to provide them with training and support. On the other hand, There's also a potential role for national human rights institutions to act as a watchdog and to assess how businesses are implementing their due diligence. And we're seeing this in a number of jurisdictions, including in Chile, in South America, where they have just conducted a sector-wide impact assessment of the fishing industry with a specific look at the salmon sector and how that whole sector is impacting human rights across the country. In relation to access to remedy, this really depends on the mandate of the National Human Rights Institution. As I know I mentioned before, some have a mandate to receive individual complaints, and when they do, they can follow up directly. Other national human rights institutions have conducted fact-finding missions to try and shine a spotlight on specific human rights abuses or violations. National human rights institutions also can play a role in mediation, in ensuring that both sides come to the table to discuss issues outside of formal justice mechanisms. Then, national human rights institutions can conduct inquiries on the issue, as I mentioned before. And you can see that again in the Philippines at the moment, where the National Human Rights Institution has conducted and concluded an inquiry into the impact of fossil fuel companies on climate change and human rights. Also, national human rights institutions can provide support to litigants in court, both directly and as an amicus curiae. And we see that in Norway, where the institute, the Ombudsperson's office, has taken a case and is supporting a case in relation to climate change at the moment. Other areas where national human rights institutions can engage on the issue is in their reporting. National human rights institutions report regularly to the UN on how a state is meeting its human rights obligations and can include within those reports how it is responding to business and human rights issues. And we're also seeing an increased engagement under the 2030 Agenda for Sustainable Development, where NHRIs are reporting at the high-level political forum. We're seeing increased collaboration between NHRIs. There is a recent initiative between Colombia and Germany where they're trying to follow the supply chain of coal and looking at both ends of that supply chain, both at the extractive end in Colombia and also at the end in Germany, and all of the human rights issues throughout the supply chain, including transportation. NHRIs are increasingly engaging with OECD national contact points, and the Global Alliance of NHRIs has a memorandum of understanding with the OECD on strengthening collaboration between these institutions, and we are seeing events and trainings in Latin America to this end. As mentioned, there are different networks. The European network makes submissions to the EU and to the Council of Europe, including on the recent developments around mandatory human rights due diligence. The Global Alliance has made submissions to the OECD on the revisions of the multinational enterprise guidelines. And of course, there is the International Treaty on Business and Human Rights, which is in development at the moment, and national human rights institutions are engaging with this and their national governments to try and make sure that it is a good treaty. The current draft articulates a role for national human rights institutions as a watchdog body. So there is a need for national human rights institutions to engage with this to ensure it reflects us properly. And then finally, I wanted to conclude with some key areas of interest for human rights institutions. Of course, there are other areas important at the national ones, but these are the areas that we're seeing reflected across all NHRIs. There's a need to work more on remedy because there are many gaps for victims to access remedy at the moment for business-related human rights abuses. We're seeing an increased need to look at gender in a business and human rights context, building from the recent work done by the UN Working Group on Business and Human Rights. and we're seeing NHRIs respond to this. Technology is of increasing interest to NHRIs, as I'm sure you're exploring through this conference, and the implications of technology, both positive and negative, often at the same time, is a key area that NHRIs want to work more on. And now there is an NHRI Alliance, which meets every month to discuss these issues. Climate, as previously discussed in the panel, is a key area that NHRIs are focusing on now, and businesses have a key role in addressing this issue. And finally, finance. The flow of money internationally is huge, and the need to articulate a human rights element to this is very important. And with that, I will finish, and thank you very much for listening.
Biz de Daniel Morris'e teşekkür ediyoruz. Mr. Morris, thank you very much for your contribution.
Thank you, Daniel Morris.
There might be some questions regarding your presentation. Thank you. Şimdi sunumları.
Now we have concluded the presentations. If there's anyone who wants to ask a question or make a comment, sir, in the first row. I'm a member of the TİHEK, and I would like to thank all participants for their contributions. Not a question, but I would like to make a contribution to Ms. Alnur's presentation, especially the development in human rights in Turkey was identified as a silent revolution in a book. And this silent revolution is about the changes made in disability. And I would like to make a comment here. I think the success will come with sharing the good examples. The law on disability was based on a rights-based approach, and the disability law in Turkey has a comprehensive approach of the disability in Turkey, and it's a rights-based law. And you have given nice examples. There were 3 country examples, but I think Turkey is also very successful in this area. I would like to give you some brief information about implementation in Turkey. In public institutions, 4%, and in private institutions, 3% quota is applied for disabled people. And in the beginning of 2000s, there were about 6,000 disabled persons in public institutions, and now it has increased about 10 times. And for physically disabled people who want to become public servants, there used to be a general exam, but now there is a special exam, and we have made special legal regulations to ensure their access to employment in the state. And we are also supporting positive discrimination for the disabled persons. And we have turned employment of the disabled into an advantage for the businesses. And we have introduced advantages for the businesses who employ disabled. And for the disabled persons who work in the public institutions, we introduce some advantages such as early pension and relocation rights, and our Ministry of Labor is also working on that. And I think that Turkey can be one of the best examples. Thank you. Please go ahead. Thank you. Burcu Biraş Roraydın, UNDP, Turkey. First of all, I would like to thank our president and everyone else who has contributed to this event. This is a wonderful event in terms of timing and the content. And I would like to thank the panelists for their interesting presentations. They touched upon very important things. And in Turkey, a few days ago, we had a kickoff event of the Business and Human Rights project. The project was funded by the Japanese government, and in this context, we are working in cooperation with TİHEK and state and civil society partners, and we work very closely with those who are working in the field. And one of our targets is that we created a preliminary assessment in cooperation with ILO last year. This is a general picture of the situation in this country, and we want to take this one step forward. And in cooperation with civil society, academia, with public sector and private sector, we will work very closely. My question is to Mr. Morris. There's a subject that we also prioritize in our project. Our purpose is to make more progress in our efforts. And you also mentioned in your presentation, you mentioned the national baseline assessment, and we want to do this in accordance with the Danish human rights institutions approach. So it is our hope to work in close collaboration with the Danish human rights institution. So our main purpose is to draft the national action plan. But what are the priorities? How can we cooperate? That was my question. Thank you.
Buraya.
Great, thank you very much for the question. It's really good to hear that you're going to undertake a national baseline assessment. I think that's a great kind of first step. And as I mentioned, I think there is a clear role that a national human rights institution can play in this regard. At the Danish Institute, yes, we've developed the methodology. Actually, we have just updated the methodology and we'll be launching it in a new digital tool in a month's time. So it's perfect that you highlight this now. I'm very happy to have a conversation with you bilaterally on what this could look like. In terms of identifying priorities, I think that really is the purpose of a national baseline assessment, to try and identify the priorities that a NAP should address based on a gap analysis, which is conducted via the national baseline assessment. I think there have been a lot of developments in national action plans of recent times, and a lot of developments in relation to national baseline assessments. We've seen a lot of them focus on Pillar 1 and Pillar 3. There's been a little less focus on Pillar 2, on the corporate responsibility to respect. But we're seeing new methodologies, including the corporate human rights benchmark, as a way of trying to assess businesses and what they're already doing on this issue. So just to return, very good to hear that you want to progress on this issue, and we'd be very open to help engage on.
Thank you. Thank you very much for your comment. And in addition to this important topic of silent revolution, as you mentioned, it's indeed very delightful to know that you've been working already on the rights-based approach to issues related to persons with disabilities. And we noted that about the quote that has been increased in public services and the positive discrimination approach. I would be interested to hear more about this. Maybe we can take this bilaterally. Thanks.
We may have other questions or contributions if there are any. Hello, everyone. From TİHEK, Turgutan Gökçe. My question will be to all the speakers in the second panel. With the armed conflict between Ukraine and Russia, some business people and academicians have commented as such. They claim that businesses should stop their operations at Russia, or else they would be violating human rights. What are your opinions in that regard? And my second question is that international human rights organizations and national human rights organizations in their respective countries, do they have any such calls for their companies to stop their operations in Russia?
Sure, I can start. This is a very interesting question, and indeed this has been on our minds, at least at UNDP, for very some time, at least. So I just want to mention that obviously there are approaches in dealing with due diligence of businesses in conflict-affected areas. There is a so-called heightened due diligence that the companies should undertake when they are operating in areas which are affected by conflict, especially if it is an armed conflict like in Ukraine. So besides the usual due diligence that they have to undertake, it has to be heightened. So they need to look also at the political analysis implications of the work that they are doing. I cannot respond clearly on your question whether the companies should exit, but they have to take in their analysis so many factors. So it depends on every individual case. I just want to mention that as UNDP, we have just published a new guidance for businesses on heightened due diligence in conflict and war. For example, in Ukraine, we looked at it as well as one of the examples, so I'll be happy to share with you.
Thank you. And are there any other speakers who would like to contribute?
Ben de bir şeyler söylemek isterim.
Indeed, I would like to say a couple of words. Actually, I do agree with Aynur'a, and I would like to compliment to her comments. These guiding principles, 7th article about business and human rights, the responsibility of businesses for human rights bring another duty to states to assist their efforts. Indeed, it is not an extra duty, but it is such a responsibility for the states to fulfill. For the the countries need to guide those companies, and if they do have any hesitations in regard to human rights, there could be certain warnings, and this is the extra duty on the shoulder of states. They need to have extra due diligence, and surely it depends on the context. When it comes to Russia and Ukraine war, The states who take certain positions will be identifying their positions. Because those companies need to follow the national legislation. And then we see the point of states' duty to fulfill this responsibility.
I agree with what the previous speaker said. The UN Guiding Principles provide a baseline for working on this topic. And the main focus should be on human rights due diligence and ensuring that businesses do no harm. The first reaction, I don't think, should be to leave. It should be to try and make a difference. But if you can't do that, then the last option always is to leave the market. However, it's not always that simple. It is quite complex. If you think about the delivery of essential goods or services in a conflict zone, if, for example, a invading power was to take control of the electricity system, should the businesses just pull out? Or should they try and continue to provide electricity to hospitals to continue the right to health, for example? It can be quite tricky. And if you look at Myanmar, there was a company called Telenor. And then after the recent coup by the military, there were increasing pressures for Telenor to give information to the state. Telenor refused, and then they decided to exit the market. When they exited their market, they had to sell the business and all of the personal information to the government. So now the government has the personal information of everybody in that country, which itself could be problematic. So what is the answer? You stay and help support a dictatorship, or you leave and possibly cause harm? It's a difficult one to work with. So I think there is need for guidance, and it's good to hear that the UNDP is providing such guidance. And I know the ombudsperson in Ukraine is also engaging in this kind of guidance as well.
Teşekkürler. Ben de son söz.
Thank you so much. And as for the last words, I would like to give myself some time. As you do know, to our Constitutional Court, there is this remedy for individual applications. As far as I do know, these guideline principles have not been a topic of application. But there are some situations that the businesses do fire their employees by just checking their WhatsApp messages, for example. Those are personal communication. And in order to raise awareness, I believe bar associations have an extra role. And TİHEK may take an active role to inform people about their rights. And in Turkey, this issue is not well appreciated. In 2012, those guideline principles have been accepted, adopted, and nearly 11 years have passed. But in Turkey, we are, I believe, just starting to talk about this. And I think effective individual applications to Constitutional Court could be a remedy for people who are suffering from such situations. And here I would like to conclude this session. I would like to thank our speakers, Ms. Bekoneova, Ms. Chimran, and Mr. Morris. Thank you so much for your contributions. We would like to thank our moderator and speakers for their contributions, and I would like to invite head of institution to deliver token of appreciation to our speakers.
Değerli katılımcılar,
Esteemed participants, we will have a brief coffee break. After the coffee break, we will start the third session of the summit.
Bir protest. Bir protest. Bir protest.
Ece Göztepe Çelik. And I would like to invite Sabina Aliyeva, Meryem Tazgirse, Ahmet Ulutaş, and also we will invite Katrin Mösvis, Sabina Aliyeva, Dilnoza Muratova for the session with the title of Human Rights Communication and Cooperation with Regional and International Mechanisms. Esteemed Chair, esteemed participants, welcome to our last session. We have 4 speakers. 15 minutes were allocated to each speaker. I will be warning you in regard to time schedule. The first speaker will be Sabina Aliyeva. She is from Azerbaijan Ombudsman Institute. She had her education in regard to public management and international relations. She has her PhD since 2000 in Azerbaijani Constitutional Court. She had different duties, and she is a Deputy Head of Department for Human Rights in Constitutional Court. And she is also assigned she is elected for the Human Rights.
Ladies and gentlemen, first of all, I would like to express my sincere gratitude to the hosting organization, direct to you, Mr. Muharrem. Thank you very much for your kind invitation. It's a great pleasure and honor for us to be here with you and with our dear colleagues from all around the world. I highly appreciate the initiative of organizing this summit, which highlights the role of national human rights institutions and the current challenges in the field of human rights in today's world. In our modern world, the human rights protection assumes high importance in unifying humans and various societies, and this is fundamental criterion for humanizing them. Referring to human rights, we mean every member of society and the rights of individual. The essence of human rights is that all human beings must have equal rights, and everyone is entitled to these rights without any discrimination. Everyone has inalienable rights from birth. In recent years, we observe increasing role of national human rights institutions in addressing the challenges in human rights, particularly in current situation that our world is facing in present days. They work on several significant activity directions relating to the protection of human rights and freedoms. The biggest advantages of the national human rights institutions are that it is open, public and democratic, independent, and has the ability to provide immediate assistance, remove some barriers, improve governance, and ensure transparency. As can be seen as a national human rights institution, the ombudsman institutions play an important role in development of democracy in our societies and protecting human rights. In this regard, in every democratic state, the capabilities of national human rights institutions should be further expanded, and they should be given full support by the governments in this direction. Being independent, they may also effectively communicate with international human rights mechanisms, which is important in respect of drawing global attention to human rights violations in certain places. Being in full compliance with Paris principles makes them more effective in addressing real human rights situations and providing valuable solutions to them. I would like to mention that this year is very important and significant for our institution. The Azerbaijan Ombudsman Institution, which is independent and functions based on the principles of openness, transparency, legality, justice, and impartiality, marks its 20th anniversary. Our institution, guided by these universal principles, contributes to development of legal consequence, legal thinking, and legal culture in society, as well as to further democratization of administration. Our institution also has a close cooperation with GANRI and its regional network of ENRI. Azerbaijan National Human Rights Institution has made also important input in drafting National Action Plan on protection of human rights in the Republic of Azerbaijan and National Program for action to raise effectiveness of the protection of human rights and freedoms in the Republic of Azerbaijan, which were approved by the presidential decree. Azerbaijan National Human Rights Institution has also made significant contribution to the promotion of business and human rights in the country and created a working group which consists of the relevant state authorities, business structures, and civil society organizations. Being a national human rights institution also allows us to take part in the sessions of the Human Rights Council of United Nations, as well as submitting parallel reports to the treaty bodies of the UN. Since the date of accreditation, our institution submitted about 20 written and oral statements to the UN Human Rights Council. We consider that being engaged in the work of the UN Human Rights Council gives us the ability to discuss related human rights issues and situations that require its attention. Under the constitutional law, the National Human Rights Institution of Azerbaijan is authorized to fulfill national preventive mechanism mandate to prevent torture and also to protect the right to access to information. To effectively carry out the mandate, we established several relevant structural units within our institution in the last few years. These units are the Department for Protection of the Right to Information, Child Rights Protection Unit, Department on Prevention of Torture, Unit on Protection of Persons with Disability Rights. Considering the important role of civil society organizations in addressing specific human rights issues in the society and their close cooperation with national human rights institutions in combating discrimination and protecting the vulnerable groups, we have also established a department on cooperation with international and civil society organizations. We attach great importance to the cooperation with international and regional networks of the Ombudsman and national human rights institutions that make significant contribution to our activities in respect of exchanging views and experience. Our institution is a member of many international and regional networks, such as International Ombudsman Institute, Asian Ombudsman Association, GANRI, ENRI, the Ombudsman Association of the Turkic States, the Ombudsman Association of the Organization of Islamic Cooperation, and some others. Such networks contribute a lot to the exchange of knowledge and experience between institutions. Speaking about the challenges to the protection of human rights today, I would like to note with a heavy heart that in the contemporary world there are serious problems and double standards in persecution of the perpetrators of the most serious crimes, such as crimes against peace and humanity and war crimes. Because these crimes lead to serious violations of the norms and principles of international human rights law and international humanitarian law. In the process of execution of the UN Security Council resolutions and gross violations of human rights. I would like to take this opportunity to share experience of my country, so-called fulfillment of the 4 UN Security Council resolutions which were adopted in the early 19th of last century. You can admit that in practice, the UN Security Council resolutions have been implemented in a few days or even a few hours concerning some countries. But if we speak about the implementation of these resolutions for my country, Azerbaijan Republic, unfortunately, we are waiting 30 years. And the fact that these norms remain on paper is a clear example of discriminatory treatment of our country. The existence of all these forms of discrimination not only violates the principle of justice, but in practice caused the commissions of war crimes, crimes against peace and humanity, which cost human lives. And the silence of international organizations on such violations leads to the recurrence of such crimes also in our days. When international community ignore these facts, these violations of, against humanity, these war crimes, it means that such kinds of violations will continue. One of the current problems to human rights at the international level is the issue of impunity. To eliminate such injustice, I consider that all criminals should be brought to justice using the current international criminal punishment mechanisms. I think the elimination of such cases and ensuring respect of the rule of law should be one of the main tasks of the international community and international organizations. National human rights institutions play a crucial role in conflict and post-conflict period. As independent institutions, they can make on-site investigations in the places where the violations took place and prepare ad hoc reports and statements. This can be an immediate call for stopping violation for human rights and taking necessary preventive actions. In the period of the Second Karabakh War, which lasted 44 days 2 years ago, we appealed to the international community and issued well-justified reports on Armenians' aggressions against Azerbaijan and military provocations, and consequently, we have issued 15 reports, 23 statements, and 24 appeals. I would like to note that some international organizations and non-governmental organizations have referred to our report. And to take this opportunity, I want to say my special thanks to the TİHEK and the head of this organization for their support, for their position. They visited Azerbaijan and we prepared together a special report concerning war crimes in our territories. Thank you very much for your fair position. Despite the liberation of our territories, we still have serious obstacles in reviving the life on those places. Nearly 1 million landmines which were planted by Armenia in the period of occupation are still serious threat for the health and life of people. Armenia fails to hand over accurate the minefield maps, and this delays the return of hundreds of thousands of our internally displaced persons to their homes with dignity and in safety.
Last 2 minutes, please.
In doing that, Armenia blatantly ignores the norms and principles of the international law. Another negative effect of the Karabakh War is the unknown fate of approximately 4,000 Azerbaijanians, including women and children, who went missing during the First Karabakh War. Since the Second Karabakh War, we don't know about the fate of 6 of our Azerbaijanis, our citizens. Apart from this, Armenia has also committed the crime of ecocide. We spoke on our first part of our date about the climate changes, but it's a serious problem because the damaging the nature, biological diversity, flora and fauna, water resources in general, the ecology of the formerly occupied territories of Azerbaijan was full destroyed the ecosystem of all region. More than 60,000 hectares of forests in those areas with rich flora and fauna were destroyed. Just 1 minute. Cut off or stolen soil and rivers were polluted and poisoned. And the biggest problem of our region is the threat of the expired Metsamor nuclear power plant located in the territory of the Republic of Armenia. It's a big threat not only for Azerbaijan, but for the whole region. Azerbaijani National Human Rights Institution has called on all relevant international organizations to take urgent measures for its immediate closure, ensuring the safe suspension of its operation and realization of all stages of radioactive waste management in full compliance with relevant international instruments. In conclusion, I would like to stress the importance of the networking of national human rights institutions and being the voice of humans who suffer from the violence. These institutions should take joint action in creating international norms and standards for the better protection and promotion of human rights. Here, I would like to conclude my speech by expressing my sincere wishes for peace and security. Thank you very much for your attention.
Çok teşekkür ediyoruz. Süreye de büyük.
Thank you so much. You have also stayed in your time schedule. Thank you. And our second speaker will be Dilnoza Muratova. And she is from Republic of Uzbekistan. She has expertise in different fields of law, and she has several scientific publications. She had her PhD in international law, and in Sweden, she completed a course on human rights. And at this point, we do see that she has various fields of interest. I will not go into the details. Women's rights, children's rights, international human rights institutions, migration law, and also Central Asia are her special interest fields. Ms. Muratova is now Deputy Head of the National Center for Human Rights of the Republic of Uzbekistan. And the floor is yours, ma'am. You have 15 minutes. Thank you.
Thank you for kind introducing. Sayın Doktor Muharrem Kılıç, değerli katılımcılar, konferans konukları, dünya medeniyetlerin kavşağı.
In this civilization dating back to centuries, it is such a pleasure for me to be here. I would like to thank you for your kind invitation.
It is also significant that today's event is being held in Ankara, a real symbol of modern Turkey, the place from which a new era began for the Turkish people. The 13th anniversary of diplomatic ties between Uzbekistan and Turkey, as well as the 5th anniversary of strategic collaboration, are celebrating this year. In May, in Bursa, the Association of National Human Rights Institutions of Turkic states was established. In the beginning of June in Tashkent, we have concluded Memorandum of Understanding between National Center for Human Rights of Uzbekistan and Human Rights and Equality Institution of Turkey. And today, we are gathered here to talk about the national human rights institutions and how we can improve them to the benefits of our citizens. National human rights institutions are a vital part of country-level human rights protection system. By raising awareness, providing advice, monitoring and holding authorities to account, they have a central role in navigating the great human rights challenges of our days, tackling both persistent concerns like discrimination and inequality, and novel issues such as the rise of implications of artificial intelligence and of the COVID-19 pandemic. Dear colleagues, to enhance human rights communication and cooperation should be one of the most important goals, so that international system for the protection and promotion and protection of human rights remains available for everyone. Today, ensuring the best communication with the regional and international mechanism is one of the key factors and an important condition for promoting human rights at all levels. We are convinced that this summit will become a platform that will allow us to coordinate the points of contact, which will bring practical results in the future. Ladies and gentlemen, the United Nations has already recognized it as the main international mechanism in the field of human rights protection. The United Nations and the Republic of Uzbekistan has a 13-year history of cooperation, and one of priorities of which is considering the protection of human rights. In international arena, Uzbekistan raises frequently the following principles: promotion and protection of human rights, respect for the rule of law, and the protecting and inherent dignity of all human beings, which includes tolerance and non-discrimination toward all. The election of Uzbekistan to the Human Rights Council for 2021 and 2023 is a clear confirmation and evidence of our country's firm commitment to the purpose and principles of UN Charter and Universal Declaration for Human Rights and strict compliance with its international obligation in this field. Today, the country has a stable political system that meets the modern criteria of democracy and human rights, and the legislative, executive, and judicial branches of government are actively working to strengthen respect for human rights and to promote human rights education throughout the country. Uzbekistan, based on the principles leaving no one behind, has developed national indicators for the implementation of the UN Sustainable Development Goals. Uzbekistan remains fully committed to the human rights promotion and protection. In June 2020, has adopted the National Human Rights Strategy. It provides for implementation of the recommendation of UN Human Rights Council and the treaty bodies. Dear participants, Uzbekistan maintains an active and constructive dialogue with the UN Charter and treaty bodies, specialized agencies, and special procedures of the UN Human Rights Council. Uzbekistan strongly supports the universal periodical review process due to its universal and transparent nature, which allows each state to inform the international community of measures taken to improve the situation in the field of observance and protection of human rights and the progress achieved in this area. Uzbekistan successfully conducted the three universal periodic reviews in 2008, 2013, and 2018. The government has prepared national action plans for the implementation of recommendations of the Human Rights Council, treaty bodies, and other human rights instruments. We have made significant progress in our interaction between the Office of High Commissioner for Human Rights and the special procedures. Over the past short period, visits of 3 special rapporteurs were carried out. Uzbekistan invites the United Nations Human Rights Commissioner for Human Rights and UN Special Rapporteur on Torture to pay a visit. Uzbekistan's commitment to human rights is manifest by the number of international human rights instruments it has subscribed to so far. Uzbekistan is a state party to 80 international human rights-related treaties, including 7 of 9 core international human rights instruments and 4 optional protocols thereto. Last year, we have ratified the UN Convention on the Rights of Persons with Disabilities. Now we intend to ratify the optional protocol to the Convention Against Torture. Uzbekistan has a good record of meeting reporting obligations under international human rights treaties. The government has submitted timely 41 periodical reports on the implementation of the main international human rights treaties, as well as on the follow-up to the recommendation of the treaty bodies' reports. For implementing the recommendation of the UN mechanisms on human rights in order to coordinate the cooperation with the state bodies in the implementation of international human rights obligations, as well as broad interaction with the international and regional human rights mechanisms, in December 2018, Uzbekistan has created national reporting and follow-up mechanism by strengthening the status of National Center for Human Rights. At the same time, a national system of monitoring of the observance of constitutional human rights and freedoms and the fulfill the international human rights obligation has been formed. It should be noted, Uzbekistan was the first Central Asia state to establish a system of national human rights institutions according to the Paris Principles, which includes a parliamentary ombudsman, children ombudsman, business ombudsman, and recently we created national preventive mechanism on model of Ombudsman Plus. Dear colleagues, in his speech at the 75th anniversary session of the UN General Assembly and the 46th session of the UN Human Rights Council, the President of Uzbekistan identified the key priorities of new Uzbekistan on human rights, which are ensuring the rights to health, gender equality, protection of the rights of the person with disabilities, protection of the youth rights, human rights education, strengthening the independence of the courts, development of international and regional cooperation on human rights. One of the new initiatives of Uzbekistan on human rights is that Uzbekistan actively participated in the United Nations World Programme for Human Rights Education. The National Action Plan for the implementation of the provision of UN Declaration on Human Rights Education and Trainings is being implemented. In the current year, the House of Human Rights was established at the National Center for Human Rights. Its goal is to become a resource center for human rights information and resources. It is planned to collect advanced human rights literature. We would be delighted if our partners contributed to the fund's enrichment. The National Human Rights Center has been continuously conducting master classes, seminars, trainings, courses on human rights education, online lessons to educate public servants, legal professionals, representatives of civil society institutions, as well as media members. National Center for Human Rights has launched human rights research on a number of pressing human rights issues. The Scientific Council for Human Rights Protection has been established. We believe it is necessary to establish collaboration in the field of human rights research. Uzbekistan also intends to continue to promote the establishment of a regional human rights mechanism in the Asia region. In this regard, a permanent platform has been created, the Samarkand Forum on Human Rights. Distinguished participants of the conference, as an active member of the Human Rights Council, Uzbekistan wishes to explicitly its continuous readiness to broad and mutual benefit cooperation with all countries of the world and practical dialogue with the United Nations. establishment of new association of national human rights institutions of Turkic countries, as well as memorandum between National Human Rights Center and TİHEK, once again shown a close relations to promote human rights. Together with the Office of High Commissioner for Human Rights, we are planning to hold a global forum on human rights education. We kindly invite all of you to participate in this global forum, which will be held in October in Tashkent. Within the framework of the global forum, we would like to propose to hold side event human rights education in Turkic states, jointly with the TİHEK and member associations. We also propose to organize summer school on the issues of national human rights institutions and UN bodies for national human rights institution representatives. Ladies and gentlemen, I would like to conclude my speech by the words of the great Mevlana Rumi, who spoke, "Bu dünyaya ayırmaya, bölmeye, parçalamaya gelmedik."
We are not here to destroy this world. We are here to heal the wounds, repair the broken ones. We are here to make peace between the fallen ones.
Important event can help ensure that we achieve such goals, and in doing so increase the role of national human rights institutions as a bridge between the human beings and the state. In this regard, we call the national human rights institutions to seek regular and constructive cooperation with relevant state bodies to promote the inclusion of human rights in legislation, policies, and programs. I believe that this summit will serve an important platform for comprehensive dialogue and exchange in the best practices and skills, center of attention and operation of all stakeholders operating with a common view for enhancing national human rights institutions' role in the protection and promotion of human rights. We believe that as long as all members of the international community join hands and gather more strength, we will be able to overcome any challenges and find new opportunities for further cooperation. I would like to congratulate you once again on the great success of the summit and look forward to having opportunity to communicate with you again. Thank you very much. Çok teşekkür ederiz.
Thank you very much. Our third speaker is Mariam Tavgriz. She is a graduate of the Law School of Tiflis University and from the Groningen University. She had a master's degree and she has another master's degree from the Tbilisi University. Between 2018 and 19, she worked at the Georgian Ombudsman and under the Department of Project Management, and since 2019 she has been the coordinator of the International Relations Office of the Georgian Ombudsman and monitoring the human rights situation and human rights education are some subjects that she has been trained in. You have 15 minutes.
Thank you for the introduction. Chairman Kilic, distinguished guests and speakers, dear colleagues, ladies and gentlemen, it is a great honor for me to be here in Ankara today to discuss the Georgia National Human Rights Institution's efforts and work in strengthening its cooperation with regional and international human rights mechanisms. Firstly, let me extend my sincere gratitude for organizing this extremely interesting event, which covers many important issues such as business and human rights, climate change, and also national human rights institutions accreditation process. Dear colleagues, before delving into details about our work and activities, I assume it will be also interesting for the participants of this event to firstly understand what is the mandate of Georgian national human rights institutions, since it is important in terms of understanding our international work. The Public Defender of Georgia is the national human rights institution under the Constitution of Georgia. tasked to oversee the observance and protection of human rights and fundamental freedoms in the country. It is a parliamentary oversight mechanism and submits to the Parliament of Georgia annual parliamentary reports. Also, the institution is fully compliant with the UN Paris Principles and has A status. We have been reaccredited in 2018. So in Georgian system, our institution is empowered with a broad mandate, meaning that the competence of the institution covers seven different mandates, including the power of classic ombudsman institution dealing with the maladministration cases. We are also national human rights institution, national preventive mechanism, equality body. We also monitor the rights of persons with disabilities as well as rights of the child, and we are also protecting the whistleblowers. So considering such a strong and broad mandate, Georgia National Human Rights Institution plays a critical role in the country, not only in terms of protecting the rights of individuals, but on the other hand also influencing some of the policy changes and also putting forward the political debates at national level. Because of our work, institution is highly respected both on the national and international levels. I would say we are a credible partner and focal point for many international organizations, also nationally, also accredited embassies in Georgia, and other stakeholders working on human rights and rule of law issues. Ladies and gentlemen, Georgian NHRI is very active when it comes to the cooperation with international and regional organizations and human rights mechanisms, including such as Human Rights Council, UN treaty bodies, and Council of Europe. We usually use international and regional platforms to advocate for the relevant policy changes. Many years of experiences have proved that this is a very useful tool. During recent year, we have submitted dozens of alternative reports, also written submissions to the relevant UN bodies, also the Council of Europe. We have also invited many times UN special reporters to assess the human rights situation in Georgia in many different directions. Of course, some of you may ask why the active involvement of national human rights institutions at international stage is critical, and what results could we achieve in this way? Let me start by underlining that international organizations such as UN or Council of Europe have many times demonstrated and underlined that NHRIs play a critical role in their national contest. And also they have called NHRIs many times to be vocal and to actively engage with them. So I would say that there are many, like couple of reasons why we should be actively engaged with the UN. First of all, I assume NHRIs which are present here have broad mandates, and under the Constitution we cover all human rights issues. Also, NHRIs have both unique role and are critical actors at national level, since we possess information about the existing human rights challenges in the country. Also, information provided by NHRIs or ombudsman institutions are credible, since we have all the facts and evidences gained through our monitoring, also through individual applications. Besides this, NHRIs play a bridging role, since we provide expertise about the existing challenges and also recommendations. So we have recommendations to the government to remedy the human rights problems in the country. Lastly, NHRI's participation and engagement not only helps the UN or any other international organizations and various mechanism bodies to better understand the challenges in our country, but it also facilitates implementation of the recommendations that we have given to the countries, to our respective governments. governments. And another question is how we do it. How do we work with the international mechanism? So Georgian NHRI, as a status NHRI, we have a mandate to refer to the UN Human Rights Council or UN special procedures, and therefore we regularly submit alternative reports and also are actively engaged with the Office of the United Nations High Commissioner for Human Rights, as well as NGOs and civil society organizations nationally. For instance, our office has already submitted alternative report many times to the UN Universal Periodic Review. For instance, recently we have submitted it for a third cycle of Georgia's review process. Besides this, when we work on those reports, we usually try to cooperate also with the civil society organizations, and we try to take as many pointers from them and include in our alternative reports. And this is very important point. I think that civil society organizations need to be present, and also we have to cooperate with them a lot. Another good example is that we use implementation of the ECTHR judgments in our country. Since Strasbourg court's judgments are also binding for the government, and therefore we try to be active in this regard, and we usually also try to submit our opinions and information to the Committee of Ministers of the Council of Europe under Rule 9 communication, and since 2016 we have submitted around 13 Rule 9 communications. Generally, I guess some of you might have questions, what kind of information do we provide to international or regional organizations? In our submissions, we usually provide details and evidences from our own work and from the latest reports, as well as from the relevant international documents issued by international organizations. At the end of and we don't stop here. Afterwards, we assess whether the Georgian government has implemented all the recommendations which we are given by, for instance, UPR or Human Rights Council or Council of Europe. And for these purposes, we usually draft reports and also inform the government about the steps which need to be taken in order. This cooperation encompasses many different directions, including, for instance, organizing joint events or campaigns to promote human rights. And at the same time, we work together with those organizations as well as the government on different issues, such as, for instance, we worked jointly on to develop human rights strategy and action plan, and I would say this is one of the success stories. Our institution is also very actively engaged with international and regional networks of national human rights institutions, and this has been already mentioned by previous speakers, and we consider this to be very important strategic priorities as it helps in raising our visibility and also enables us to work together with other peer institutions on regional and global levels on some of the pressing human rights issues. And these networks provide us with opportunities to work with other peer institutions, to listen to their practices and experiences, identify some of the common issues or problems that we could address jointly. And GANRI, ENRI, and other networks are very useful also in terms of making it possible for the voices of NHRIs being heard by international organizations. And of course, through these networks, we can push forward some of the pressing human rights problems and work together to remedy them. One of the good examples that I would like to talk about is Georgian NHRI's work with regards to the rights of older persons. We have actually used GANRI's working group on the rights of older persons to push forward the development of international binding mechanisms on the right of older persons. And this has been done, of course, in cooperation with other peer national human rights institutions as well as international non-government organizations. So I don't want to take much of your time, and finally let me briefly underline some of the important issues that I have said earlier in my speech. So as I have mentioned, there are many opportunities for NHRIs to engage with international and regional human rights mechanisms, and it is very important. Also, NHRIs have increasingly positioned themselves as relevant national actors who can provide trustworthy information about the human rights situation in their countries. Besides this, NHRIs can contribute to thematic debates and the development of new international human rights standards. NHRIs are also well placed to monitor implementation of recommendations given to the governments within different international human rights mechanisms, and at the same time, they can ensure follow-up with those
Genel Müdür Yardımcısı, İstanbul Hukuk Fakültesinden mezun olduğu
Our next speaker is Dr. Ahmet Ultaş, Minister of Justice, Deputy Director General for Foreign Relations and European Union. He worked as a consultant between 2018 and 2019. He is still working at the Ministry of Justice. He completed his master's and doctoral degree at Gazi University. He is an expert in response to terrorism, criminal law, and legal aid.
Su içme bölümü dakikalardan
Does drinking water count as 1 minute? Okay. Esteemed head of TİHEK, participants and valued guests, valued international guests, ladies and gentlemen, I would like to salute you all with my deepest respect. Before moving on to my presentation, I would like to thank the head of TİHEK, Muharrem Kılıç. Today I'm going to talk about human rights mechanisms of the UN, and later I will move on to the global and regional mechanisms and their relations with other mechanisms. Our valued Professor Ece mentioned that I have attended many international forums on human rights, and as the other human rights law experts, I sought an answer to the question how we can make progress in the field. I have come up with this book. Of course, it needs further development, further research, so I have come up with these circles. These are the preventive mechanisms, and some accept individual applications and some accept national applications. And we have heard valuable presentations today. This is a macro perspective. National mechanisms, do they provide protection? Yes. Are they sufficient? No. There are conventions and treaties. Do they protect? Are they sufficient? No. This is like the layers of an onion. So we need to get to know these layers. So I wanted to show you a general picture here. Now I will move on to the real content of my presentation. This is not only about the human rights. This was a comprehensive presentation. This is the UN Geneva office that hosts 90% of the institutions I have contact with. This is an important office in terms of having close relations with human rights institutions. I heard that the canton of Geneva was against the idea of having this office in Geneva, but they convinced them so that 176 country representatives would come together to have important meetings, important conventions. There is a director of this center, Tatiana Alyova. So why am I talking about Geneva? This is the heart of the UN system in terms of human rights. Geneva is not only the heart of the human rights work. I wanted to give you a general picture, and this is all publicly available information. There are many important international institutions from the Federation of Post to others. This is a center. Geneva is a center where many international institutions come together. So what is the purpose for the establishment of the UN? To protect human rights? Yes, of course. This was discussed in the convention, founding convention. So a catalog was not added, but the first article of the United Nations is to protect the human rights. How does UN handle the human rights issue? Security Council, General Assembly, the Social Council, and there are other committees that are related to UN, temporary courts, and these are all institutions who have human rights related roles. I don't have enough time to get into detail now. So there are main mechanisms under the UN, and there are others which were established later under additional protocols. So previous president of the Chile is now handling the institution. So who is the spokesperson of the UN in terms of human rights? This is the question that they asked. And in 2016, the number of members, the structure of the forum was changed. And they gather with a call from the 1/3 of the members. And the assessment mechanism is an interesting mechanism. They provide a report for each country every 4 to 6 months. I'm not going to go into details. There's one working group on arbitrary detention, arbitrary arrests. I attach great importance to that, because when we look at what is going on with the refugees around the world now, and there's another working group about the forced disappearance, and they also follow related cases around the world. The working group on arbitrary arrest, they handle the arbitrary arresting of individuals, and the complaints from national levels come to the UN, and the UN reviews the complaint and notifies the relevant states. They have an internal decision mechanism. And there's the forced disappearance working group. They have a list of the disappeared. Their purpose is not to find those who disappeared, but their purpose is to keep them on the list until the persons appear again. Special reports are classified into different subjects. You can read them from the screen. I don't want to lose any more time on this. So what are the mechanisms that are based on the UN conventions? Human Rights Committee is the head of all, and Economic, Social, and Cultural Rights Committee was also established. Convention of Prevention of Violence, Child Rights Convention. These are all based on conventions. I will focus on the committees. The threshold may seem lower in these committees in comparison to the European Court of Human Rights. They have general recommendations, and I recommend that you take a look at their web page. Please review their websites. And Civil and Political Rights Convention is the basis of the Human Rights Committee, and this is not only for some individuals. This applies to every human being. In that sense, it is universal. The second part, I would like to discuss the Article 26. So here we have an article from the Turkish Constitution. This is the part where our constitution is related to the international rights. In this section, Turkish constitution says that constitutional rights derive from the international rights. Basic rights and freedoms derive from the international rights and obligations. So what is international law? And we find the answer in the UN's So here we have an article of the International Court of Justice in the third section of my book, I gave examples from the American and Japanese law. This is the main point. We refer to the international law.
Buna ciddi itiraz getiren bir makalesi var. Lütfen merak edenlerin okumasını tavsiye ederim. İşte
There's this citation in my book. This is the general idea. So there are binding and non-binding articles of the UN, and the non-binding ones are the basis of the international law that are related to the culture, and some of them become jus cogens. And we must remember these rules. Last 2 minutes. Thank you. So, how are these mechanisms related to each other and in between each other? Joint Declaration on the Reinforcement of Cooperation between the Council of Europe, Secretariat, Office of the United Nations, High Commissioner. So there's a joint work between the UN and the European Human Rights Conventions and Councils. They have contact points, and the General Secretary of the UN must work more closely with the European experts in order to standardize the processes and to benefit from the acquis that is very rich. And I know that Special Reporter on Violence Against Women and the CEDAW work together. They work closely since there has been so much discrimination against refugees. They work with the refugee committees and they publish general recommendations. For instance, on the child issues, they come together with the child committee and issue recommendations. And these are the addresses where complaints can be made. These are the addresses. If you're interested, I can share my presentation with you. Thank you for your attention. I salute you with my deepest respect. Thank you very much. Thank you, all speakers, for good time management. If there are any comments or questions from the floor, now we can hear them. Any questions? Hello, thank you, Burcu Aydın, UNDP Turkey. Thank you for the detailed presentation, for your comments. My question is to Mr. Ahmet Ulutaş. As the last speaker, he provided detailed, comprehensive perspective of the UN. When we talk about the connection of international mechanism, these are also relevant to the internal regulations. This is also about the design of the new mechanisms, and the national action plans come into question here. In March 2021, our Ministry of Justice initiated the work on National Action Plan and the 9.3b, the article of the National Action Plan. This is also on our agenda. I would like to read out this article. Taking into consideration the UN guiding principles, business world, and employment-related guiding principles shall be identified, and this is supposed to be completed within 1 year, and we are working in close cooperation with the Ministry of Labor. And this was a nice step to take, and in terms of improvement of internal mechanisms, and we identified guiding principles in this country. You are representing the Ministry of Justice, and as an executive at the Director General for Foreign Relations and European Union, there's a new directive on mandatory due diligence, and this is relevant to your field, and it's going to have an impact on Turkey in terms of commerce. So, how is our Ministry of Justice going to be planning the process in terms of this directive's reflections on Turkey? We know that the Ministry of Labor is also working on it. They have drafted their reports, and as UNDP Turkey, we would like to contribute. We would like to implement awareness-raising activities. What is foreseen as the next step? I'm asking you because the Ministry of Justice is responsible for the coordination. What is your opinion on this? Thank you. Thank you very much for your question, but you made a small presentation too in the form of a question. I see that you made a comprehensive investigation on the issue. The Ministry of Justice is responsible on this, and they have a specific team, an expert team who are working closely on the issue. As I mentioned in my book, Young Guiding Principles on Business and Human Rights, and I mentioned that in my book, and I think a translation would be beneficial in terms of making a contribution to human rights field. They have an internal mechanism, and with the participation of the relevant institutions, they make decisions on the issue. Thank you. Any other questions from the floor? I guess not. Then we will conclude this session. I would like to thank all speakers, all our international participants. Thank you very much. I would like to thank our moderator and our speakers for their valuable contribution. I would like to invite Muhammed Ecevit for award ceremony.
Şimdi üyelerimizi ve konuşmacılarımızı
Now I would like to invite the head of institution and all participants to the stage for a family photo.